construed and applied to promote its underlying purposes and policies. 2. Underlying purposes and policies of this Act are: a. To simplify, clarify, and modernize the law governing commercial transactions. b. To permit the continued expansion of commercial practices through custom, usage, and agreement of the parties. c. To make uniform the law among the various jurisdictions. 3. The effect of provisions of this Act may be varied by agreement, except as otherwise provided in this Act, and except that the obligations of good faith, diligence, reasonableness, and care prescribed by this Act may not be disclaimed by agreement, but the parties may by agreement determine the standards by which the performance of such obligations is to be measured if such standards are not manifestly unreasonable. 4. The presence in certain provisions of this Act of the words "unless otherwise agreed" or words of similar import does not imply that the effect of other provisions may not be varied by agreement under subsection 3. 3-103, 4. 4. Good faith means honesty in fact and the observance of reasonable commercial standards of fair dealing. On Cornell this section reads reserved. Wow, why is it gone? 4-104, b. Good faith, see section 3-103. Notice this section is removed in its entirety out of the web version for Cornell Law 2. 5-102, a. 7. 7. Good faith means honesty in fact in the conduct or transaction concerned. 6-103, 3. Article 6 is governed by sales, bulk sales, see 6-103, 3. 7-403 and 7-404. 4. Person entitled under the document means holder in the case of a negotiable document, or the person to whom delivery is to be made by the terms of or pursuant to written instructions under a non-negotiable document. See 8-102, 7, for definition of entitlement holder. 7-404. No liability for good faith delivery pursuant to receipt or bill. A bailee who in good faith, including observance of reasonable commercial standards, has received goods and delivered or otherwise disposed of them according to the terms of the document of title or pursuant to this article is not liable therefor. This rule applies even though the person from whom he received the goods had no authority to procure the document or to dispose of the goods, and even though the person to whom he delivered the goods had no authority to receive them. 8-102, 10. 7. Entitlement holder means a person identified in the records of a securities intermediary as the person having a security entitlement against the securities intermediary. If a person acquires a security entitlement by virtue of section 8-501, b. 2, or 3, that person is the entitlement holder. 8-102, 10. Good faith for the purposes of the obligation of good faith in the performance or enforcement of contracts or duties within this article, means honesty in fact and the observance of reasonable commercial standards of fair dealing. Again, this section is reserved on Cornell's website. 9-102, 43. 43. Good faith means honesty in fact in the conduct or transaction concerned. Again, notice the section on Cornell law reads reserved. Is this getting coincidental or what? To summarize every section 1, 3, 4, 5, 8, 9 all tell you good faith as in 1-105, 2 and 6 talk about sales yet direct you back to 1-105 for good faith provisions, 7 directs you to an entitled party, which is found in Article 8, and Article 8 brings you back to 1 for the good faith clause, plus it talks about an entitled party. And Cornell hides most the good faith provisions of the UCC. Over time I have heard so much about the new Article 9 and how important it is to read it because it affects everything in commerce. First read the paragraph below and then look at the section from Article 9 itself and ask yourself how important it really is, or is not. Now, in order for Article 9 to pass any test, one should ask themselves, if Article 9 governs any interest, regardless of form, yet the party asserting any interest cannot do so without violating law, or there is evidence that that party asserting an interest really cannot assert an interest based upon their own application and registration to do business in a given state, how can Article 9 even apply to them or you or even the issue? Subpart 2. Applicability of Article 9 to 109. Scope. A. General scope of article. Except as otherwise provided in subsections C and D, this article applies to 1. A transaction, regardless of its form, that creates a security interest in personal property or fixtures by contract. 2. An agricultural lien. 3. A sale of accounts, chattel paper, payment intangibles, or promissory notes. 4. A consignment. 5. A security interest arising under Section 2-401, 2-505, 2-711, 3, or 2A 508(5), as provided in Section 9 to 110, and 6. A security interest arising under Section 4 to 210 or 5 to 118. b. Security interest in secured obligation. The application of this article to a security interest in a secured obligation is not affected by the fact that the obligation is itself secured by a transaction or interest to which this article does not apply. c. Extent to which article does not apply. This article does not apply to the extent that 1. A statute, regulation, or treaty of the United States preempts this article. 2. Another statute of the state expressly governs the creation, perfection, priority, or enforcement of a security interest created by the state or a governmental unit of the state. 3. A statute of another state, a foreign country, or a governmental unit of another state or a foreign country, other than a statute generally applicable to security interests, expressly governs creation, perfection, priority, or enforcement of a security interest created by the state, country, or governmental unit, or 4. The rights of a transferee beneficiary or nominated person under a letter of credit are independent and superior under Section 5 to 114. d. Inapplicability of article. This article does not apply to 1. A landlord's lien, other than an agricultural lien. 2. A lien, other than an agricultural lien, given by statute or other rule of law for services or materials, but Section 9 to 333 applies with respect to priority of the lien. 3. An assignment of a claim for wages, salary, or other compensation of an employee. 4. A sale of accounts, chattel paper, payment intangibles, or promissory notes as part of a sale of the business out of which they arose. 5. An assignment of accounts, chattel paper, payment intangibles, or promissory notes which is for the purpose of collection only. 6. An assignment of a right to payment under a contract to an assignee that is also obligated to perform under the contract. 7. An assignment of a single account, payment intangible, or promissory note to an assignee in full or partial satisfaction of a pre-existing indebtedness. 8. A transfer of an interest in or an assignment of a claim under a policy of insurance, other than an assignment by or to a healthcare provider of a healthcare insurance receivable and any subsequent assignment of the right to payment, but Sections 9 to 315 and 9 to 322 apply with respect to proceeds and priorities in proceeds. 9. An assignment of a right represented by a judgment, other than a judgment taken on a right to payment that was collateral. 10. A right of recoupment or set-off, but a. Section 9 to 340 applies with respect to the effectiveness of rights of recoupment or set-off against deposit accounts, and b. Section 9 to 404 applies with respect to defenses or claims of an account debtor. 11. The creation or transfer of an interest in or lien on real property, including a lease or rents thereunder, except to the extent that provision is made for a. Liens on real property in Sections 9 to 203 and 9 to 308. b. Fixtures in Section 9 to 334. c. Fixture filings in Sections 9 to 501, 9 to 502, 9 to 512, 9 to 516, and 9 to 519, and d. Security agreements covering personal and real property in Section 9 to 604. Now this changes one's thoughts of what Article 9 really can or cannot do. Let's read on for a better understanding of law in its commercial applications. Also found in the revised Article 9, it reads form of transaction. The form of the transaction or the label that the parties give to the transaction is irrelevant for the purposes of determining whether Article 9 applies. Rather, the determination is based on the economic reality of the transaction. Law, that which must be obeyed and followed by citizens, subject to sanctions or legal consequences, is a law. Citizens exist in the economic reality of corporate America. In Old English jurisprudence, law is used to signify an oath, or the privilege of being sworn. Many U.S. citizens take oaths, even teachers, and there are tons of privileges too. Contract, a promissory agreement between two or more persons that creates, modifies, or destroys a legal relation. An agreement, upon sufficient consideration, to do or not to do a particular thing. According to Bouvier's Law Dictionary, we find this to read, agreement, contract. The consent of two or more persons concurring, respecting the transmission of some property, right, or benefit, with a view of contracting an obligation. BAC. About HT, Commander Dig. HT, Ven. About HT, plowed. 17, 1 Commander Contract 2, 5 Easts are 16. It will be proper to consider, 1. The requisites of an agreement, 2. The kinds of agreements, 3. How they are annulled. 2-1. To render an agreement complete 6 things must concur, there must be, 1. A person able to contract, 2. A person able to be contracted with, 3. A thing to be contracted for, 4. A lawful consideration, or quid pro quo, 5. Words to express the agreement, no signature again, only intent, 6. The assent of the contracting parties. Plowed. 161, colit. 35, b. An agreement between 2 or more parties, preliminary step in of which is offer by one and acceptance by other, in which minds of parties meet and concur in understanding of terms. According to Black's law, fourth agreement is, a coming or knitting together of minds, in law a concord of understanding and intention between 2 or more parties with respect to the effect upon their relative rights and duties, of certain past or future facts or performances. Consent, a concurrence of wills. Voluntarily yielding the will to the proposition of another. Acquiescence or compliance therewith. Agreement, the act or result of coming into harmony or accord. Accord, in practice. To agree or concur as one judge with another. Agreements are contracts and contracts fall under the UCC. The UCC is the Uniform Commercial Code. The UCC has been around for thousands of years but just recently became the uniform law in all 50 states. As of July 1, 2001 it makes uniform, to draw less confusion on Article 9 provisions only. Not all agreements fall under Article 9. Some actually still fall under the prior Article 9 and then only if Article 9 itself applies. Because secured parties do not have complete control over where issues of perfection may be litigated, a prudent secured party should prepare for the possibility that perfection may be determined by a court sitting in a state that has not enacted revised Article 9, and, thus, will be applying the choice of law rules of former Article 9. If a dispute concerning the perfection arises in a federal, 6, or state court of a particular state, the forum state, both former Article 9 and revised Article 9 require the application of the choice of law rules in the forum state's Article 9 in order to determine the state, the perfection state, whose substantive laws govern perfection of the security interest. 7. It should be noted that the perfection state in many cases will not be the forum state, rather, the version of Article 9 in effect in the forum state will often direct the court to apply the laws of a different state to determine whether perfection exists. The secured party should consider the possibility that more than one jurisdiction might be the forum state and that there may be several perfection states. The secured party should then consider whether to comply with any of the perfection rules of former Article 9 and, in the case of collateral under revised Article 9 that is not within the scope of former Article 9, whether to comply with any determinable perfection rules under other applicable law apart from former Article 9. A secured party should consider complying with the substantive perfection rules of I. Revised Article 9, 2. Former Article 9, and 3. Other law to the extent any of the following applies. Tangible collateral, such as ordinary goods and instruments, is or might in the future be located in a state other than the state in which the debtor is located under revised Article 9. The debtor's location, as determined under either former Article 9 or revised Article 9, is or might in the future be in a state other than the state in which the debtor is located under revised Article 9. The collateral consists or will consist of assets, such as deposit accounts, that are outside the scope of former Article 9, and the perfection of a security interest in those assets, may require action in a state in which former Article 9 is still in effect. Now for a complete understanding of default. Page 4 of the ABA book entitled The Default Provisions of Revised Article 9 reads, the secured creditor cannot exercise its rights under Part 6, Default Provisions, until after default. The first-time visitor to Article may 9 be surprised to discover that, like its predecessor, old Article 9, Part 6 does not define default. Nor does any other provision of Article 9 or 1-201, the General Definitions section of the UCC, define this all-important term. Instead, the definition, which may be as long as the creditor's arm and as broad as the counsel's imagination, is left to the agreement of the parties. 27 CFR 72.11, Code of Federal Regulations. Meaning of terms, as used in this part, unless the context otherwise requires, terms shall have the meanings ascribed in this section. Words in the plural form shall include the singular, and vice versa, and words importing the masculine gender shall include the feminine. The terms includes and including do not exclude things not enumerated which are in the same general class. Commercial crimes, any of the following types of crimes, federal or state offenses against the revenue laws, burglary, counterfeiting, forgery, kidnapping, larceny, robbery, illegal sale or possession of deadly weapons, prostitution, including soliciting, procuring, pandering, white slaving, keeping house of ill fame, and like offenses, extortion, swindling and confidence games, and attempting to commit, conspiring to commit, or compounding any of the foregoing crimes. Addiction to narcotic drugs and use of marijuana will be treated as if such were commercial crime. All crime is commercial. More on consent. Michigan legal guidelines. 2. Detention and arrest. A. Levels of encounters. When reviewing the legality of police interactions with citizens, courts initially assess the nature and extent of the contact. To aid in this analysis, interactions, or encounters, are divided into 3 conceptual categories. First, there are encounters of a consensual nature. This has sometimes been called the common law right to inquire. This is a right to ask a question, enjoyed by all citizens, whether they work in law enforcement or not. Occupying the next tier of encounters are interactions of a more intrusive character. These are encounters commonly called detentions, investigatory stops or Terry stops. The justifications offered by law enforcement for this more forceful contact must be based on facts that are specific and articulable, and lead to a rational inference or a reasonable suspicion that criminal activity is being undertaken. The final level of encounter is a formal arrest. To justify this action, law enforcement officials must possess a higher degree of suspicion, i.e., probable cause to believe that a crime is being, or has been, perpetrated and that a specific person committed it. B. Consensual encounters, right of inquiry. The basic premise underlying a consensual encounter is that it is voluntary. Such an encounter is an interaction based on consent and is terminable by either party. Law enforcement officers do not infringe on a citizen's Fourth Amendment rights by merely approaching him or her at random in a public place in order to ask a few questions, as long as a reasonable person would understand that he or she could refuse to cooperate and excuse themselves from the exchange, if they choose to do so. A bit about the UCC 1-207 or 1-308 section. A brief test of this section in practice. 1-308, formally 1-207. Performance or acceptance under reservation of rights. 1. A party who with explicit reservation of rights performs or promises performance or assents to performance in a manner demanded or offered by the other party does not thereby prejudice the rights reserved. Such words as without prejudice, under protest or the like are sufficient. 2. Subsection 1, does not apply to an accord and satisfaction. According to Black's Law Dictionary, accord means, accord, in practice. An agreement to accept, see accord and satisfaction. The same Black's Law Dictionary for accord and satisfaction means, an agreement between two persons, one of whom has a right of action against the other, that the latter should do or give, and the former accept, something in satisfaction of the right of action different from, and usually less than, what might be legally enforced. Now UCC 1-308, or 1-207, in section 1, makes one believe they have their rights reserved. However, after reading 2, and the definitions of accord and satisfaction, it is easy to see that you are still a party. Even though you are reserving your rights as a party under commercial law, are you not reserving all your rights but only the rights that come from the very agreement you admitted you are a party to? In reality, let's take a look at a hypothetical contract and see what this means. A man goes to a bank and gets a loan. The bank told this man that he would be borrowing the bank's money for this loan. The man later finds out that the bank in fact did not loan their own capital stock and that it is a violation for a bank to use their own capital stock to make a loan. This man wishes to end business, payment, with the bank, yet he signed all his documents with UCC 1-308, or 1-207. He also puts this UCC 1-308, or 1-207, on all communication to the bank explaining his position. A very important question at this time is, how can he, in this hypothetical scene, keep asserting he is a party to the agreement but wants all his rights reserved? Remember, the agreement is the law in commercial law. He is saying that he is a party to a void and deceptive contract. If a contract is bad and void and unfair, deceptive, or false, then why would one even attempt to admit to being a party to it? Just thoughts to ponder as you go through this. The District of Columbia has adopted the UCC. It is irrelevant if the feds have adopted it or not, as they have no venue in which to use it. The several states acquiesced via the Buck Act to become states within states, UCC 1 to 105, and support the feds in their bankruptcy. If the government is operating under the Constitution, then it is operating under Article 1, Section 10, concerning the non-interference with obligations of contract and thusly outside any constitutional restraints or reservations. Title 26 being private law, i.e. colorable, falls here. Government at every level, collectively, has minimal contacts with the people, i.e. driver license, voter registration, fishing license, mobile home registration, trailer and vehicle registration, and so on, ad nauseam. These are all agreements under the UCC. A contract is completed when there is a meeting of the minds and not necessarily when products, papers, funds, or services are exchanged, etc. There are court cases. All governmental functions are now private, not public functions. To prove this statement, read the following case quote as relevant to any discussion of governmental authority regarding the money issue. All courts in every state of the Union, and federal as well, operate under the Clearfield Doctrine from the case of Clearfield Trust Co. v. U.S. 318. U.S. 363, 1943. This case explains the Clearfield Doctrine as this: governments descend to the level of a mere private corporation and takes on the character of a mere private citizen where private corporate commercial paper Federal Reserve notes are concerned. For purposes of suit, such corporations and individuals are regarded as an entity entirely separate from government. Bank of U.S. v. Planters Bank, 9 Wheaton, 22 U.S., 904, 6L. ed. 24 added. The definition of money becomes extremely relevant once the above is known and understood. So, the question is now, what is the substance of the money used by the government entity coming against you? Money as defined in the Constitution for the several states united at Article I, Section 10, Clause 1, or money as defined in the Uniform Commercial Code, UCC, adopted by your state legislature. We have had cases dismissed because the prosecutor would not let us question the officer as to what medium of exchange do you get paid in. The UCC itself states that its definitions are controlling over dictionary definitions. See those UCC definitions as the words are used in the following instances: creditor, debtor, remedy, defendant, document to title, representative, security interest, and loads more in the same section you cited for the definition of money in your article. You must understand that we are all presumed to be the debtor in all interactions with the now private government creditor, dealing in the bankrupt debt/credit system now prevalent throughout the country. When any state agency comes against you, normally no constitutional arguments can be allowed, since it is presumed that you are dealing, knowingly, voluntarily and willfully, in the commercial law of contracts, implied or written. In that state of the forum, you lose all protections of both state and federal constitutions. In your encounter with the term state, be advised that it does not mean the geographical area that you live in. The term state has at least seven meanings in most dictionaries. See UCC 1 to 105, 1, on separate states or nations. In Black's Law Dictionary, under the definition of forum contractus is states, forum contractus. The forum of the contract, the court of the place where a contract is made, the place where a contract is made, considered as a place of jurisdiction. You will note it reads the court where a contract is made. We all are guilty of contracting into the jurisdiction and venue of the courts by our answering yes when asked if we understand the charges. See Black's definition of understand and you will find it to mean agreement. Further, see Black's on lex contractus. In conflicts, the law of the place where the contract was formed, though the term today has undergone changes from the time that substantive questions of law were decided by the law of the place of the making, while procedural questions were decided by the law of the forum. Also see Black's on lex fori. The law of the forum, or court, that is, the positive law of the state, country, or jurisdiction of whose judicial system the court where the suit is brought or remedy sought is an integral part. Substantive rights are determined by the law of the place where the action arose, lex loci, while the procedural rights are governed by the law of the place of the form, lex fori. Mitchell v. Mitchell, L.A. App. 5 Sir, 483 So.2 D 1152, 1154. Emphasis added. See Black's on public revenue, public money, and you will find it to state that those funds collected go into the government's treasury. Since we know that all the revenue now collected goes to the Federal Reserve, a non-government private bank, the IMF, and the World Bank, and not to the government's treasury, we can safely state they are not collecting public revenue or dealing in public money. Correct. See Grace Commission report during former President Reagan's administration. If it is not public revenue, it must be private revenue. Correct. Under this private system, the only claim by a creditor against a debtor is via the financing statement or the meeting of the minds, understanding, i.e. agreement. Ask for their name to see who you are dealing with. Ask for their claim in the form of a financing statement, contract, agreement, evidentiary instrument, etc. bearing your bona fide signature, wherein you have agreed to the relationship of creditor and debtor. No evidence of a contract, there can be no debt, let alone a debtor. The UCC itself states no person is liable on an instrument unless his signature appears thereon, UCC 3-401, 1. It then goes on to tell how his signature is made. 2. A. UCC definitions: person, party, is presumed to have the requisite contract. When you demand they produce it and they fail, that is material evidence of the non-existence of the agreement. If they can't produce it, it is a false claim and they are bearing false witness and shall suffer punishment therefore. UCC 1-201 definitions section says at 12, creditor, includes, an executor or administrator of an insolvent debtor or assignee's estate. Question: are all administrators in government working as such for an insolvent debtor, i.e. the federal bankrupt government? If your answer is yes, see next. It is well settled in administrative law that, it is the accepted rule, not only in state courts, but, of the federal courts as well, that when a judge is enforcing administrative law they are described as mere extensions of the administrative agency for superior reviewing purposes, as a ministerial clerk for an agency. 30 calories 596, 167 calories 762. A judge ceases to sit as a judicial officer because the governing principles of administrative law provides that courts are prohibited from substituting their evidence, testimony, record, arguments, and rationale for that of the agency. Additionally, courts are prohibited from substituting their judgments for that of the agency. AISIVUS 568 F2D 284. Judges who become involved in enforcement of mere statutes, civil or criminal in nature and otherwise, act as mere clerks of the involved agency. K.C. Davis, Admin Law, CH1, CTP. West's 1965 ed. Their supposed court becoming thus a court of limited jurisdiction as a mere extension of the involved agency for mere superior reviewing purposes. K.C. Davis, Admin Law, P95, CTP, 6 ed. West 1977, FRCVGE 28 IUS 464, Keller VPE, 261 US 428. Thus, the federal government is bankrupt, UCC definition, HJR 192, the state governments have agreed to assist, administration, in the bankruptcy, they are both using private commercial paper as money, they have become private corporations or individuals, by doing so, they are therefore, an entity entirely separate from government. The UCC is the codification of the international law of contracts. On the subject, there is no fraud involved as it all involves obligations of contract. Even God enforces bad contracts. A party is not a party to the action until his signature on an instrument is produced. A party may waive rights, UCC equals remedy, by failure to claim them timely. U.S. v. Johnson, we are all participants in the largest scam, Black's definition, ever devised by man. Thus, the Constitution for the several states united is irrelevant to the lawfulness of the UCC. Contracts, an overview. Contracts are promises that the law will enforce. The law provides remedies if a promise is breached or recognizes the performance of a promise as a duty. Contracts arise when a duty does or may come into existence, because of a promise made by one of the parties. To be legally binding as a contract, a promise must be exchanged for adequate consideration. Adequate consideration is a benefit or detriment which a party receives which reasonably and fairly induces them to make the promise/contract. For example, promises that are purely gifts are not considered enforceable because the personal satisfaction the grantor of the promise may receive from the act of giving is normally not considered adequate consideration. Certain promises that are not considered contracts may, in limited circumstances, be enforced if one party has relied to his detriment on the assurances of the other party. Contracts are mainly governed by state statutory and common, judge-made, law and private law. Private law principally includes the terms of the agreement between the parties who are exchanging promises. This private law may override many of the rules otherwise established by state law. Statutory law may require some contracts be put in writing and executed with particular formalities. Otherwise, the parties may enter into a binding agreement without signing a formal written document. See 110 of the Restatement. Most of the principles of the Common Law of Contracts are outlined in the Restatement Second of the Law of Contracts published by the American Law Institute. See Restatement Second of Contracts. The Uniform Commercial Code, whose original articles have been adopted in nearly every state, represents a body of statutory law that governs important categories of contracts. The main articles that deal with the law of contracts are Article 1, General Provisions, and Article 2, Sales. Sections of Article 9, Secured Transactions, governs contracts assigning the rights to payment in security interest agreements. Contracts related to particular activities or business sectors may be highly regulated by state and/or federal law. See law relating to other topics dealing with particular activities or business sectors. Secured Transaction Law, an overview. A security interest arises when in exchange for a loan a borrower agrees, in a security agreement, that the lender, the secured party, may take specified collateral owned by the borrower if he or she should default on the loan. A security interest also provides the secured party with the assurance that if the debtor should go bankrupt he or she may be able to recover the value of the loan by taking possession of the specified collateral instead of receiving only a portion of the borrower's property after it is divided among all creditors. See bankruptcy. Security agreements are contracts. Article 9 of the Uniform Commercial Code governs security interests in personal property. It has been adopted, with some modifications, by every state. A security agreement must comply with other state laws governing contracts. See Contracts. Article 9 of the Uniform Commercial Code covers most types of security agreements for personal property that are both consensual and commercial. See 9-102, 2, and 9-104 of the Code. This includes fixtures, personal property that is fixed to real property such as a water heater. Statutory liens, e.g. a mechanic's lien, are generally not governed by Article 9 but by the individual statute that creates them. See 9-102, 2, and 9-310 of the Code. Article 9 contains a statute of frauds which requires a security agreement to be in writing unless it is pledged. See 9-203, 1, of the Code. A pledged security agreement arises when the borrower transfers the collateral to the lender in exchange for a loan, example upon broker. The perfection of a security agreement allows a secured party to gain priority to the collateral over any third party. To perfect a security agreement, the filing of a public notice is usually required. See 9-302, 9305 of the Code. Sales Law, an overview. Transactions for the sale and leasing of goods is governed mainly by sales laws of each state. Every state, with the exception of Louisiana, has adopted Article 2 of the Uniform Commercial Code, UCC, as the main body of law regulating transactions in goods. Goods are defined as all things movable and identified to the contract of the sale. See 2-105 of the UCC. It does not include secured transactions, leases, money exchanged as the price, or real property, land and property permanently attached to a piece of land. See secured transactions. To be identified to the contract, a good must be existing and one of the objects that is or will be exchanged. See 2-106, 1, and 2-501, 1, of the UCC. Transactions between merchants and consumers and those solely between merchants are regulated by Part 2. All transactions that are for more than $500 must be in writing. See 2-201, 1, of the UCC. Article 2 regulates every phase of a transaction for the sale of goods and provides remedies for problems that may arise. It provides for implied warranties of merchantability and fitness. See 2-314, 2-315 of the UCC. There is also a duty of good faith in the UCC that is applicable to all the sections. See 1-203 of the UCC. If a contract contains unconscionable provisions, a court may discard the contract or the provisions. See 2-203 of the UCC. Negotiable Instruments Law, an overview. Negotiable instruments are mainly governed by state statutory law. Every state has adopted Article 3 of the Uniform Commercial Code, UCC, with some modifications, as the law governing negotiable instruments. The UCC defines a negotiable instrument as an unconditioned writing that promises or orders the payment of a fixed amount of money. Drafts and notes are the two categories of instruments. A draft is an instrument that orders a payment to be made. An example is a check. A note is an instrument that promises that a payment will be made. Certificates of deposit, CDs, are notes. Drafts and notes are commonly used in business transactions to finance the movement of goods and to secure and distribute loans. To be considered negotiable, an instrument must meet the requirements stated in Article 3. Negotiable instruments do not include money, payment orders governed by Article 4A, fund transfers, or to securities governed by Article 8, investment securities. Checks are negotiable instruments but are mainly covered by Article 4 of the UCC. See also banking law. Secured transactions may contain negotiable instruments but are predominantly covered by Article 9 of the UCC. See also secured transactions. If there is a conflict between the articles of the UCC, both Article 4 and 9 govern over Article 3. Tort law, an overview. Torts are civil wrongs recognized by law as grounds for a lawsuit. These wrongs result in an injury or harm constituting the basis for a claim by the injured party. While some torts are also crimes punishable with imprisonment, the primary aim of tort law is to provide relief for the damages incurred and deter others from committing the same harms. The injured person may sue for an injunction to prevent the continuation of the tortious conduct or for monetary damages. See damages. Among the types of damages the injured party may recover are loss of earnings capacity, pain and suffering, and reasonable medical expenses. They include both present and future expected losses. There are numerous specific torts including trespass, assault, battery, negligence, products liability, and intentional infliction of emotional distress. Torts fall into three general categories: intentional torts, example intentionally hitting a person; negligent torts, causing an accident by failing to obey traffic rules; and strict liability torts, example liability for making and selling defective products. See products liability. Intentional torts are those wrongs which the defendant knew or should have known would occur through their actions or inactions. Negligent torts occur when the defendant's actions were unreasonably unsafe. Strict liability wrongs do not depend on the degree of carefulness by the defendant, but are established when a particular action causes damage. Tort law is state law created through judges, common law, and by legislatures, statutory law. Many judges and states utilize the Restatement of Torts, Second, as an influential guide. The Restatement is a publication prepared by the American Law Institute whose aim is to present an orderly statement of the general law of the United States. For choice of law, jurisdiction. When first diving into this extremely important topic, one must have a clear understanding of the choice parties have for the choice of law option based upon the agreement. Inside the new Article 9 on page 56 it reads, both current and revised Article 9 provide that the secured party is generally liable to the debtor for any loss caused by the secured party's failure to comply with the enforcement provisions of Article 9-507, 1, revised 9-625, b. But case law under current Article 9 in non-uniforms in applying 9-507, 1, to determine what sanctions may be imposed on the non-complying secured party. Revised Article 9 provides that the value of the collateral is presumed to have equaled the entire secured debt, eliminating the deficiency claim, unless the secured party is able to rebut this presumption. Rev 9-626, a. 3. Under both current and revised Article 9, a statutory penalty may be imposed on a non-complying secured party, without damages being proven, where the collateral is consumer goods. 9-507, 1, Rev 9-625, c. 2. Jurisprudence, an overview. The word jurisprudence derives from the Latin term jurisprudentia, which means the study, knowledge, or science of law. In the United States, jurisprudence commonly means the philosophy of law. Legal philosophy has many aspects, but four of them are the most common. The first and the most prevalent form of jurisprudence seeks to analyze, explain, classify, and criticize entire bodies of law. Law school textbooks and legal encyclopedias represent this type of scholarship. The second type of jurisprudence compares and contrasts law with other fields of knowledge such as literature, economics, religion, and the social sciences. The third type of jurisprudence seeks to reveal the historical, moral, and cultural basis of a particular legal concept. The fourth body of jurisprudence focuses on finding the answer to such abstract questions as what is law. How do judges, properly, decide cases? Apart from different types of jurisprudence, different schools of jurisprudence exist. Formalism, or conceptualism, treats law like math or science. Formalists believe that a judge identifies the relevant legal principles, applies them to the facts of a case, and logically deduces a rule that will govern the outcome of the dispute. In contrast, proponents of legal realism believe that most cases before courts present hard questions that judges must resolve by balancing the interests of the parties and ultimately drawing an arbitrary line on one side of the dispute. This line, realists maintain, is drawn according to the political, economic, and psychological inclinations of the judge. Some legal realists even believe that a judge is able to shape the outcome of the case based on personal biases. Apart from the realist-formalist dichotomy, there is the classic debate over the appropriate sources of law between positivist and natural law schools of thought. Positivists argue that there is no connection between law and morality and the only sources of law are rules that have been expressly enacted by a governmental entity or court of law. Naturalists, or proponents of natural law, insist that the rules enacted by government are not the only sources of law. They argue that moral philosophy, religion, human reason, and individual conscience are also integrate parts of the law. There are no bright lines between different schools of jurisprudence. The legal philosophy of a particular legal scholar may consist of a combination of strains from many schools of legal thought. Some scholars think that it is more appropriate to think about jurisprudence as a continuum. Now that you understand what law contracts and jurisprudence are, let's take a closer look at the choice of law sections of the UCC. One of the most important sections of the ABA book revised Article 9 is on page 47. It reads: choice of law. To determine a security interest has attached, has been perfected, or has priority over another interest, it is necessary to ask what law applies. If a dispute occurs in a particular forum in a UCC jurisdiction, the first step is to look to the choice of law rules from Article 9 of the forum jurisdiction to determine which jurisdiction's laws the forum jurisdiction is required to apply. The choice of law rules in the UCC do not address what law a non-UCC jurisdiction would apply. Contract choice of law. The governing law specified in the security agreement will usually be respected by the forum jurisdiction for determining the contractual rights and obligations of the debtor and the secured party, as long as the transaction bears a reasonable relation to the jurisdiction chosen. 1-105, 1. The secured party and the debtor may not by their contract vary the mandatory choice of law rules in current or revised Article 9 dealing with the perfection and priority of a security interest. 1-105. Territorial application of the Act, parties' power to choose applicable law. 1. Except as provided hereafter in this section, when a transaction bears a reasonable relation to the state and also to another state or nation, the parties may agree that the law either of the state or of such other state or nation shall govern their rights and duties. Failing such agreement, this Act applies to transactions bearing an appropriate relation to the state. 2. Where one of the following provisions of this Act specifies the applicable law, that provision governs and a contrary agreement is effective only to the extent permitted by the law, including the conflict of laws rules, so specified. Rights of creditors against sold goods. Section 2-402. Applicability of the article on leases. Sections 2A105 and 2A106. Applicability of the article on bank deposits and collections. Section 4-102. Governing law in the article on funds transfers. Section 4A507. Letters of credit. Section 5-116. Bulk sales subject to the article on bulk sales. Section 6-103. Applicability of the article on investment securities. Section 8-110. Law governing perfection, the effect of perfection or non-perfection, and the priority of security. Interests and agricultural liens. Sections 9-301 through 9-307. 2-402. Rights of sellers' creditors against sold goods. 1. Except as provided in subsections 2 and 3. Rights of unsecured creditors of the seller with respect to goods which have been identified to a contract for sale are subject to the buyer's rights to recover the goods under this article. Sections 2-502 and 2-716. 2. A creditor of the seller may treat a sale or an identification of goods to a contract for sale as void if as against him a retention of possession by the seller is fraudulent under any rule of law of the state where the goods are situated, except that retention of possession in good faith and current course of trade by a merchant seller for a commercially reasonable time after a sale or identification is not fraudulent. 3. Nothing in this article shall be deemed to impair the rights of creditors of the seller. A. Under the provisions of the article on secured transactions, Article 9, or B. Where identification to the contract or delivery is made not in current course of trade but in satisfaction of or as security for a pre-existing claim for money, security, or the like, and is made under circumstances which under any rule of law of the state where the goods are situated would apart from this article constitute the transaction of fraudulent transfer or voidable preference. 3 to 102. Subject matter. A. This article applies to negotiable instruments. It does not apply to money, to payment orders governed by Article 4A, or to securities governed by Article 8. B. If there is conflict between this article and Article 4 or 9, Articles 4 and 9 govern. C. Regulations of the Board of Governors of the Federal Reserve System and operating circulars of the Federal Reserve Bank supersede any inconsistent provision of this article to the extent of the inconsistency. 4 to 102. Applicability. A. To the extent that items within this article are also within Articles 3 and 8, they are subject to those articles. If there is conflict, this article governs Article 3, but Article 8 governs this article. B. The liability of a bank for action or non-action with respect to an item handled by it for purposes of presentment, payment, or collection is governed by the law of the place where the bank is located. In the case of action or non-action by or at a branch or separate office of a bank, its liability is governed by the law of the place where the branch or separate office is located. 4A 507. Choice of law. A. The following rules apply unless the affected parties otherwise agree, or subsection C applies. 1. The rights and obligations between the sender of a payment order and the receiving bank are governed by the law of the jurisdiction in which the receiving bank is located. 2. The rights and obligations between the beneficiary's bank and the beneficiary are governed by the law of the jurisdiction in which the beneficiary's bank is located. 3. The issue of when payment is made pursuant to a funds transfer by the originator to the beneficiary is governed by the law of the jurisdiction in which the beneficiary's bank is located. B. If the parties described in each paragraph of subsection A have made an agreement selecting the law of a particular jurisdiction to govern rights and obligations between each other, the law of that jurisdiction governs those rights and obligations, whether or not the payment order or the funds transfer bears a reasonable relation to that jurisdiction. C. A funds transfer system rule may select the law of a particular jurisdiction to govern I. Rights and obligations between participating banks with respect to payment orders transmitted or processed through the system, or 2. The rights and obligations of some or all parties to a funds transfer, any part of which is carried out by means of the system. A choice of law made pursuant to clause I is binding on participating banks. A choice of law made pursuant to clause 2 is binding on the originator, other sender, or a receiving bank having notice that the funds transfer system might be used in the funds transfer, and of the choice of law by the system when the originator, other sender, or receiving bank issued or accepted a payment order. The beneficiary of a funds transfer is bound by the choice of law if, when the funds transfer is initiated, the beneficiary has noticed that the funds transfer system might be used in the funds transfer, and of the choice of law by the system. The law of a jurisdiction selected pursuant to the subsection may govern, whether or not that law bears a reasonable relation to the matter in issue. D. In the event of inconsistency between an agreement under subsection B and a choice of law rule under subsection C, the agreement under subsection B prevails. E. If a funds transfer is made by use of more than one funds transfer system and there is inconsistency between choice of law rules of the systems, the matter in issue is governed by the law of the selected jurisdiction that has the most significant relationship to the matter in issue. 5 to 116. Choice of law and forum. A. The liability of an issuer, nominated person, or advisor for action or omission is governed by the law of the jurisdiction chosen by an agreement in the form of a record signed or otherwise authenticated by the affected parties in the manner provided in section 5 to 104, or by a provision in the person's letter of credit, confirmation, or other undertaking. The jurisdiction whose law is chosen need not bear any relation to the transaction. B. Unless subsection A applies, the liability of an issuer, nominated person, or advisor for action or omission is governed by the law of the jurisdiction in which the person is located. The person is considered to be located at the address indicated in the person's undertaking. If more than one address is indicated, the person is considered to be located at the address from which the person's undertaking was issued. For the purpose of jurisdiction, choice of law, and recognition of interbranch letters of credit, but not enforcement of a judgment, All branches of a bank are considered separate juridical entities, and a bank is considered to be located at the place where its relevant branch is considered to be located under the subsection. C. Except as otherwise provided in the subsection, the liability of an issuer, nominated person, or advisor is governed by any rules of custom or practice, such as the uniform customs and practice for documentary credits, to which the letter of credit, confirmation, or other undertaking is expressly made subject. If I. This article would govern the liability of an issuer, nominated person, or advisor under subsection A, or B. 2. The relevant undertaking incorporates rules of custom or practice, and 3. There is conflict between this article and those rules as applied to that undertaking. Those rules govern except to the extent of any conflict with the non-variable provisions specified in section 5-103, c. D. If there is conflict between this article and Article 3, 4, 4a, or 9, this article governs. E. The forum for settling disputes arising out of an undertaking within this article may be chosen in the manner and with the binding effect that governing law may be chosen in accordance with subsection A. 5-103. Scope. A. This article applies to letters of credit and to certain rights and obligations arising out of transactions involving letters of credit. B. The statement of a rule in this article does not by itself require, imply, or negate application of the same or a different rule to a situation not provided for, or to a person not specified, in this article. C. With the exception of the subsections, A, and D, sections 5-102, A, 9, and 10, 5-106, D, and 5-114, D, and except to the extent prohibited in sections 1-302 and 5-117, d. The effect of this article may be varied by agreement or by a provision stated or incorporated by reference in an undertaking. A term in an agreement or undertaking generally excusing liability or generally limiting remedies for failure to perform obligations is not sufficient to vary obligations prescribed by this article. D. Rights and obligations of an issuer to a beneficiary or a nominated person under a letter of credit are independent of the existence, performance, or non-performance of a contract or arrangement out of which the letter of credit arises or which underlies it, including contracts or arrangements between the issuer and the applicant and between the applicant and the beneficiary. 6-103. Applicability of Article 1. Except as otherwise provided in subsection 3, this article applies to a bulk sale if A. The seller's principal business is the sale of inventory from stock, and B. On the date of the bulk sale agreement the seller is located in the state, or, if the seller is located in a jurisdiction that is not a part of the United States, the seller's major executive office in the United States is in the state. 2. A seller is deemed to be located at his or her place of business. If a seller has more than one place of business, the seller is deemed located at his or her chief executive office. 3. This article does not apply to A. A transfer made to secure payment or performance of an obligation. B. A transfer of collateral to a secured party pursuant to Section 9-609. C. A sale of collateral pursuant to Section 9-610. D. Retention of collateral pursuant to Section 9-620. E. A sale of an asset encumbered by a security interest or lien if I. All the proceeds of the sale are applied in partial or total satisfaction of the debt secured by the security interest or lien, or 2. The security interest or lien is enforceable against the asset after it has been sold to the buyer and the net contract price is 0. 8-110. Applicability, choice of law. A. The local law of the issuer's jurisdiction, as specified in subsection D, governs 1. The validity of a security. 2. The rights and duties of the issuer with respect to registration of transfer. 3. The effectiveness of registration of transfer by the issuer. 4. Whether the issuer owes any duties to an adverse claimant to a security, and 5. Whether an adverse claim can be asserted against a person to whom transfer of a certificate or uncertificated security is registered, or a person who obtains control of an uncertificated security. B. The local law of the securities intermediary's jurisdiction, as specified in subsection E, governs 1. Acquisition of a security entitlement from the securities intermediary. 2. The rights and duties of the securities intermediary and entitlement holder arising out of a security entitlement. 3. Whether the securities intermediary owes any duties to an adverse claimant to a security entitlement, and 4. whether an adverse claim can be asserted against a person who acquires a security entitlement from the securities intermediary or a person who purchases a security entitlement or interest therein from an entitlement holder. C. The local law of the jurisdiction in which a security certificate is located at the time of delivery governs whether an adverse claim can be asserted against a person to whom the security certificate is delivered. D. Issuer's jurisdiction means the jurisdiction under which the issuer of the security is organized or, if permitted by the law of that jurisdiction, the law of another jurisdiction specified by the issuer. An issuer organized under the law of the state may specify the law of another jurisdiction as the law governing the matters specified in subsection A. 2 through 5. V. Rules on perfection, attachment, and priority. The most important elements that must be known and understood under the UCC are: 1. Perfection, filing. Not always mandatory. 2. Attachment, most powerful of all. No attachment, no perfection, or control. 3. Possession, in possession of document. 4. Control, not in possession but in control. Someone holds for you. 5. Priority, whoever attaches first has priority. Priority grants enforcement. Enforcement to the collateral cannot be accomplished until the above are met. Perfection. The fundamental policy underlying perfection is to permit discovery of security interests without complete reliance upon making an inquiry through the debtor. Source: ABCs of the UCC Revised Article 9, 9-310. Filing. 9-310. When filing required to perfect security interest or agricultural lien, security interests and agricultural liens to which filing provisions do not apply. A. General rule: perfection by filing. Except as otherwise provided in subsection B and section 9-312 B, a financing statement must be filed to perfect all security interests and agricultural liens. B. Exceptions: filing not necessary. The filing of a financing statement is not necessary to perfect a security interest. 1. That is perfected under section 9-308 D, E, F, or G. 2. That is perfected under section 9-309 when it attaches. 3. In property subject to a statute, regulation, or treaty described in section 9-311 A. 4. In goods in possession of a bailee which is perfected under section 9-312 D, 1, or 2. 5. In certificate securities, documents, goods, or instruments which is perfected without filing or possession under section 9-312 E, F, or G. 6. In collateral in the secured party's possession under section 9-313. 7. In a certificate security which is perfected by delivery of the security certificate to the secured party under section 9-313. 8. In deposit accounts, electronic chattel paper, investment property, or letter of credit rights which is perfected by control under section 9-314. 9. In proceeds which is perfected under section 9-315, or 10, that is perfected under section 9-316. C. Assignment of perfected security interest. If a secured party assigns a perfected security interest or agricultural lien, a filing under this article is not required to continue the perfected status of the security interest against creditors of and transferees from the original debtor. 9-308. When security interest or agricultural lien is perfected, continuity of perfection. A. Perfection of security interest. Except as otherwise provided in this section and section 9-309, a security interest is perfected if it has attached and all of the applicable requirements for perfection in sections 9-310 through 9316 have been satisfied. A security interest is perfected when it attaches if the applicable requirements are satisfied before the security interest attaches. B. Perfection of agricultural lien. An agricultural lien is perfected if it has become effective and all of the applicable requirements for perfection in section 9-310 have been satisfied. An agricultural lien is perfected when it becomes effective if the applicable requirements are satisfied before the agricultural lien becomes effective. C. Continuous perfection, perfection by different methods. A security interest or agricultural lien is perfected continuously if it is originally perfected by one method under this article and is later perfected by another method under this article, without an intermediate period when it was unperfect. D. Supporting obligation. Perfection of a security interest in collateral also perfects a security interest in a supporting obligation for the collateral. E. Lien securing right to payment. Perfection of a security interest in a right to payment or performance also perfects a security interest in a security interest, mortgage, or other lien on personal or real property securing the right. F. Security entitlement carried in securities account. Perfection of a security interest in a securities account also perfects a security interest in the security entitlements carried in the securities account. G. Commodity contract carried in commodity account. Perfection of a security interest in a commodity account also perfects a security interest in the commodity contracts carried in the commodity account. Attachment. Attachment does not mean attachment by contract to an individual like most may believe or try to find. They will not find it anywhere. The reason is simple. The UCC only allows for an interest to be created in a property right based upon an agreement. Attachment requires three things, and without these three things no attachment, perfection, possession, let alone priority or enforcement can exist. 1. A security agreement be made. 2. Value be given. 3. The debtor have right in the collateral to begin with. Attachment can be found also in the revised Article 9 book from the American Bar to read. Attachment is a term used to describe the moment at which a security interest becomes enforceable against the debtor. Now a question to ask yourself here. If the debtor never transferred nor assigned anything because of a deceptive, false, bogus, or void contract, how can one have attachment? See how the debtor is a very key role here? Keep in mind again in the same book from the ABA it reads, as a general matter, the debtor can only grant a security interest in whatever ownership or other rights it holds. Similarly, the secured party can generally enjoy no greater rights in the collateral than the debtor holds. A lot of folks get confused with the debtor and secured party issue. Who has the power? Most think the secured party has the power. However, if the debtor is the seller of or the owner of the property to begin with, who exactly gives power or rights or any interest in the property? The debtor is a more powerful position to be in after thinking logically to begin with. Also, for clarification, the ABA revised Article 9 book states it should be emphasized that only an attached security interest can become a perfected security interest. With this in mind, it is very easy to prove the debtor had the right, otherwise no secured party could have an interest to begin with. 9 to 309. Security interest perfected upon attachment. The following security interests are perfected when they attach. 1. A purchase money security interest in consumer goods, except as otherwise provided in Section 9-311, b. with respect to consumer goods that are subject to a statute or treaty described in Section 9-311, a. 2. An assignment of accounts or payment intangibles which does not by itself or in conjunction with other assignments to the same assignee transfer a significant part of the assignor's outstanding accounts or payment intangibles. 3. A sale of a payment intangible. 4. A sale of a promissory note. 5. A security interest created by the assignment of a healthcare insurance receivable to the provider of the healthcare goods or services. 6. A security interest arising under Section 2 to 401, 2 to 505, 2 to 711, 3, or 2A 508, 5, until the debtor obtains possession of the collateral. 7. A security interest of a collecting bank arising under Section 4 to 210. 8. A security interest of an issuer or nominated person arising under Section 5 to 118. 9. A security interest arising in the delivery of a financial asset under Section 9-206, c. 10. A security interest in investment property created by a broker or securities intermediary. 11. A security interest in a commodity contract or a commodity account created by a commodity intermediary. 12. An assignment for the benefit of all creditors of the transferor and subsequent transfers by the assignee thereunder, and 13. A security interest created by an assignment of a beneficial interest in a decedent's estate, and 14. A sale by an individual of an account that is a right to payment of winnings in a lottery or other game of chance. Possession, 9 to 312. Perfection of security interests in chattel paper, deposit accounts, documents, goods covered by documents, instruments, investment property, letter of credit rights, and money, perfection by permissive filing, temporary perfection without filing or transfer of possession. b. Control or possession of certain collateral. Except as otherwise provided in Section 9-315, c. and d. for proceeds. 1. A security interest in a deposit account may be perfected only by control under Section 9 to 314. 2. And except as otherwise provided in Section 9-308, d. A security interest in a letter of credit. Right may be perfected only by control under Section 9 to 314, and 3. A security interest in money may be perfected only by the secured parties taking possession under Section 9 to 313. F. Temporary perfection, goods or documents made available to debtor. A perfected security interest in a negotiable document or goods in possession of a bailee, other than one that has issued a negotiable document for the goods, remains perfected for 20 days. Without filing if the secured party makes available to the debtor the goods or documents representing the goods for the purpose of 1. Ultimate sale or exchange, or 2. Loading, unloading, storing, shipping, transshipping, manufacturing, processing, or otherwise dealing with them in a manner preliminary to their sale or exchange. G. Temporary perfection, delivery of security certificate or instrument to debtor. A perfected security interest in a certificate, security or instrument remains perfected for 20 days without filing if the secured party delivers the security certificate or instrument to the debtor for the purpose of 1. Ultimate sale or exchange, or 2. Presentation, collection, enforcement, renewal, or registration of transfer. Control, 9 to 310. When filing required to perfect security interest or agricultural lien, security interests and agricultural liens to which filing provisions do not apply. 9 to 310, b. 8. In deposit accounts, electronic chattel paper, investment property, or letter of credit. Rights which is perfected by control under Section 9 to 314. A security interest in deposit accounts, electronic chattel paper, or letter of credit rights is perfected by control under Section 9 to 104, 9 to 105, or 9 to 107 when the secured party obtains control and remains perfected by control only while the secured party retains control. C. Investment property, time of perfection by control, continuation of perfection. A security interest in investment property is perfected by control under Section 9 to 106 from the time the secured party obtains control and remains perfected by control until 1. The secured party does not have control, and 2. One of the following occurs. A. If the collateral is a certificate security, the debtor has or acquires possession of the security certificate. B. If the collateral is an uncertificated security, the issuer has registered or registers the debtor as the registered owner, or C. If the collateral is a security entitlement, the debtor is or becomes the entitlement holder. 9 to 314. Perfection by control. A. Perfection by control. A security interest in investment property, deposit accounts, letter of credit rights, or electronic chattel paper may be perfected by control of the collateral under Section 9 to 104, 9 to 105, 9 to 106, or 9 to 107. B. Specified collateral, time of perfection by control, continuation of perfection. A security interest in deposit accounts, electronic chattel paper, or letter of credit rights is perfected by control under Section 9 to 104, 9 to 105, or 9 to 107 when the secured party obtains control and remains perfected by control only while the secured party retains control. C. Investment property, time of perfection by control, continuation of perfection. A security interest in investment property is perfected by control under Section 9 to 106 from the time the secured party obtains control and remains perfected by control until 1. The secured party does not have control, and 2. One of the following occurs. A. If the collateral is a certificate security, the debtor has or acquires possession of the security certificate. B. If the collateral is an uncertificated security, the issuer has registered or registers the debtor as the registered owner, or C. If the collateral is a security entitlement, the debtor is or becomes the entitlement holder. Priority. Priority is what is needed for enforcement under the UCC. Now for those who still believe Article 9 is where it all is, please allow me to quote from the ABA regarding the revised Article 9 and priority. Page 13 reads, in part, the rebuttal presumption rule that applies to deficiencies in commercial transactions does not apply to a consumer transaction. Now the UCC defines a consumer transaction as one in which 1. An individual incurs an obligation primarily for personal, family, or household purposes. 2. A security interest secures the obligation, and 3. Any of the collateral is held primarily for personal, family, or household purposes. Please read on to have a better understanding, knowing now that you must leave the consumer transaction out of the equation. Priority rules. Priority rule v. Cutoff rule. A cutoff rule permits a qualifying party to take the collateral free of competing interest. If a cutoff rule does not apply, then a priority rule is used. Priority rules determine which claimant's interest will be first satisfied out of the collateral's value. Once that interest is satisfied, the remaining value of the collateral is available to the other claimants. Priority based on first in time. Fortunately, some general principles underlie most priority rules, making them easier to understand, remember, and apply. The basic priority principle awards priority to the party who is first in time. The key to understanding security interest priorities is knowing when priority is based on first to attach, first to file, or first to perfect, and when an exception such as cutoff rule permits a subsequent interest to prevail. The answers to these questions depend on the nature of the competing claims and, often, the nature of the claimed collateral. Pre-filing for priority. Even though filing is a method of perfection, perfection cannot occur until the security interest has attached. 9-308, A. Attachment does not occur until the creditor has given value, the debtor has the rights in the property, and the debtor has by agreement created the security interest. 9-308. When security interest or agricultural lien is perfected, continuity of perfection. A. Perfection of security interest. Except as otherwise provided in this section and section 9-309, a security interest is perfected if it has attached and all of the applicable requirements for perfection in sections 9-310 through 9316 have been satisfied. A security interest is perfected when it attaches if the applicable requirements are satisfied before the security interest attaches. 9-322. Priorities among conflicting security interests in and agricultural liens on same collateral. 1. Conflicting perfected security interests and agricultural liens rank according to priority in time of filing or perfection. Priority dates from the earlier of the time of filing covering the collateral is first made or the security interest or agricultural lien is first perfected, if there is no period thereafter when there is neither filing nor perfection. 2. A perfected security interest or agricultural lien has priority over a conflicting unperfect security interest or agricultural lien. 3. The first security interest or agricultural lien to attach or become effective has priority if conflicting security interests and agricultural liens are unperfect. 9-317. Interests that take priority over or take free of unperfected security interest or agricultural lien. A. Conflicting security interests and rights of lien creditors. An unperfect security interest or agricultural lien is subordinate, lower right, to the rights of 1. A person entitled to priority under section 9-322, and 2. Except as otherwise provided in subsection E, a person that becomes a lien creditor before the earlier of the time the security interest or agricultural lien is perfected or a financing statement covering the collateral is filed. B. Buyers that receive delivery. Except as otherwise provided in subsection E, a buyer, other than a secured party, of tangible chattel paper, documents, goods, instruments, or a security certificate takes free of a security interest or agricultural lien if the buyer gives value and receives delivery of the collateral without knowledge of the security interest or agricultural lien and before it is perfected. C. Lessees that receive delivery. Except as otherwise provided in subsection E, a lessee of goods takes free of a security interest or agricultural lien if the lessee gives value and receives delivery of the collateral without knowledge of the security interest or agricultural lien and before it is perfected. D. Licensees and buyers of certain collateral. A licensee of a general intangible or a buyer, other than a secured party, of accounts, electronic chattel paper, general intangibles, or investment property other than a certificate security takes free of a security interest if the licensee or buyer gives value without knowledge of the security interest and before it is perfected. E. Purchase money security interest. Except as otherwise provided in sections 9-320 and 9-321, if a person files a financing statement with respect to a purchase money security interest before or within 20 days after the debtor receives delivery of the collateral, the security interest takes priority over the rights of a buyer, lessee, or lien creditor which arise between the time the security interest attaches and the time of filing. 9-331. Priority of rights of purchasers of instruments, documents, and securities under other articles, priority of interests in financial assets and security entitlements under Article 8. A. Rights under Articles 3, 7, and 8 not limited. This article, Article 9, does not limit the rights of a holder in due course of a negotiable instrument, a holder to which a negotiable document of title has been duly negotiated, or a protected purchaser of a security. These holders or purchasers take priority over an earlier security interest, even if perfected, to the extent provided in Articles 3, 7, and 8. b. Protection under Article 8. This article does not limit the rights of or impose liability on a person to the extent that the person is protected against the assertion of an adverse claim under Article 8, c. Filing not notice. Filing under this article, Article 9, does not constitute notice of a claim or defense to the holders or purchasers or persons described in subsections a and b. I hope that now with a slightly better understanding of the code you have picked up the importance of attachment, as it is the key and fundamental part of priority and having any standing for a possible claim. As you have read, the section was mostly copy and pasted, but with the red highlighted sections it should have been better understood and followed. Again, keep in mind, just because someone, including yourself, may have a UCC file does not mean you have any claim or right. There are some very tricky rules that one must comply with, or else they will be in for a shock when the claim is nothing more than giving the UCC unit $ for filing nothing at all. Now for some good faith, reasonableness, and care. Ever heard these terms? What do they mean? How can anyone have any recourse to violations of any of these all-important terms? 1 to 102. Purposes, rules of construction, variation by agreement. 2. Underlying purposes and policies of this Act are: a. To simplify, clarify, and modernize the law governing commercial transactions. b. To permit the continued expansion of commercial practices through custom, usage, and agreement of the parties. c. To make uniform the law among the various jurisdictions. 3. The effect of provisions of this Act may be varied by agreement, except as otherwise provided in this Act, and except that the obligations of good faith, diligence, reasonableness, and care prescribed by this Act may not be disclaimed by agreement, but the parties may by agreement determine the standards by which the performance of such obligations is to be measured if such standards are not manifestly unreasonable. 1 to 203. Obligation of good faith. Every contract or duty within this Act imposes an obligation of good faith in its performance or enforcement. What is an entitlement right? 8-102, g. Entitlement holder means a person identified in the records of a securities intermediary as the person having a security entitlement against the securities intermediary. If a person acquires a security entitlement under Section 8501, 2, b, or c, that person is the entitlement holder. 8 to 501. Securities account defined, acquisition of security entitlement, conditions, directly held financial asset, issuance not as security entitlement. 1. Securities account means an account to which a financial asset is or may be credited in accordance with an agreement under which the person maintaining the account undertakes to treat the person for whom the account is maintained as entitled to exercise the rights that comprise the financial asset. 2. Except as otherwise provided in subsections 4 and 5, a person acquires a security entitlement if a securities intermediary does one or more of the following: a. Indicates by book entry that a financial asset has been credited to the person's securities account. b. Receives a financial asset from the person or acquires a financial asset for the person and, in either case, accepts it for credit to the person's securities account. c. Becomes obligated under other law, regulation, or rule to credit a financial asset to the person's securities account. 3. If one or more conditions described in subsection 2, a, b, or c, have been met, a person has a security entitlement even though the securities intermediary does not itself hold the financial asset. 4. If a securities intermediary holds a financial asset for another person, and the financial asset is registered in the name of, payable to the order of, or specially indexed to the other person, and has not been indexed to the securities intermediary or in blank, the other person is treated as holding the financial asset directly rather than as having a security entitlement with respect to the financial asset. 5. Issuance of a security is not establishment of a security entitlement. A security entitlement is actually a sui generis form of property interest, a hybrid between property and contract consisting of a bundle of several carefully meshed components. 1. Property interest in the underlying security or financial asset. 2. Rights against third parties. 3. In personam rights against the intermediary. A combination of property rights and contract rights resulting from an undertaking of one to provide to another the rights that constitute a security or certain other assets. An entitlement holder acquires a security entitlement when the intermediary credits the asset to the entitlement holder's account. Now, before going on further with who is or who is not entitled to a document or a right, please read this preface regarding Article 8 from the American Bar Association. Preface to Article 8 Security Entitlements. Chapter 1, Introduction. A brief history. The major concepts underlying the current version of Article 8 can be best understood in light of a short historical overview. The drafting of Article 8 began in the 1940s and 1950s with the purpose of conferring on a wider variety of securities the negotiable status, including the ability of transferees to acquire their interests free of adverse claims, see Chapter 3.b, then enjoyed by instruments under the Uniform Negotiable Instruments Law and by conventional stock certificates under the Uniform Stock Transfer Act. At that time, the existence of physical instruments, example stock certificates, was a key element of the securities holding system and their delivery a necessary step in any transfer. Whenever securities were traded, whether the trade was initiated in person, over the telephone or, more recently, by computer, the settlement of the trade required that physical certificates be delivered from the seller to the purchaser. In the case of securities in registered form, as opposed to bearer form, discussed infra, the securities often had to be re-registered in the purchaser's name on the issuer's books or indexed to the purchaser or accompanied by an executed stock or bond power, giving the purchaser authority to re-register the securities. The first completed versions of Article 8, approved in 1952, 1953, and 1958, and not widely enacted, recognized the concept of constructive delivery of securities held in street name by brokers, but it was not until the 1962 version, prompted by a variety of non-uniform amendments adopted in New York, that Article 8 included provisions for the transfer and pledge of securities held within a central depository system or clearing corporation. Clearing corporations are now defined as entities registered as clearing agencies under federal securities law, Federal Reserve banks, and certain other regulated persons that provide clearance or settlement services. These provisions were not, however, adequate to deal with the growing pattern of multiple intermediary relationships. Transfer of physical certificates was, and remains, a highly labor-intensive and complicated process. By the late 1960s, as a result of increased trading activity and the nature of the steps involved to effect transfer, a so-called paperwork crunch ensued. The securities industry's system for processing the settlement of transactions simply became overburdened. One response to this problem came from the U.S. Treasury's Bureau of the Public Debt, which issued regulations in 1967 providing for the issuance and maintenance of Treasury bills, notes, and bonds in completely intangible form. The current version of these regulations is described briefly at the end of this chapter. Another response came in the form of certain revisions to Article 8 itself, adopted by the UCC sponsoring organizations in 1978. This version of Article 8 sought to reduce the systemic burden of transferring physical certificates by recognizing the role of multiple intermediary relationships, as the earlier versions had not, and by providing for a system in which issuers would no longer need to issue certificates at all. Instead, ownership of certain securities, uncertificated securities, could be reflected merely by an entry in the records of the issuer in favor of the owner. Transaction confirmations and book entries by intermediaries could effect purchases of securities, whether certificate or uncertificated. The system of uncertificated securities provided for by the 1978 amendments was not widely adopted by the marketplace. One notable exception is the mutual fund market. Transfers of mutual fund shares, however, are uncommon. Changes in mutual fund share ownership occur through redemption and new issuance. Instead, an extensive pattern of security immobilization and indirect holding has developed. Under this pattern, physical certificates are still issued but tend not to be in the hands of the ultimate beneficial owners. The securities are registered in the name of, and immobilized with, clearing corporations such as the Depository Trust Company, for most publicly traded corporate equity securities, corporate debt securities, and municipal debt securities, Participants Trust Company, for certain mortgage-backed securities, and other depositories that hold securities for the benefit of their participants. For technical reasons, the securities are actually registered in the name of a nominee of the clearing corporation. The nominee of the Depository Trust Company, DTC, is Seed & Co., and that of Participants Trust Company is MBSCC & Co. The certificates are often in jumbo form, example evidencing 10,000 or more shares of common stock or $100 million of debt with a single certificate. The depository's books indicate the ownership interests of the banks or brokers that are its members, and the records of those intermediaries, in turn indicate the ownership interests of their customers, i.e., the actual investors and beneficial owners. The identities of the latter need not be, and generally are not, known to the issuer. Besides failing to account for important realities of the system that it governed, the 1978 version of Article 8 also carried forward certain rules that were undesirable from the standpoint of systemic efficiency. To take one important example, a person asserting an adverse claim retained the right to recover securities, or their value, from any transferee other than a bona fide purchaser, yet this status was impossible to attain for purchasers holding though any intermediary other than a clearing corporation. Prior. 8-315, 8-313, 2. This specter of recapture meant that the vast majority of securities transactions took place subject to doubt, albeit somewhat theoretical doubt, about their finality. B. Principal objectives of the 1994 revision. The 1994 revisions to Article 8, and to related portions of Article 9, represent an effort to overhaul commercial law rules for securities transfers so as to reflect the realities of modern securities holding and trading practices. Changes to the 1978 version of Article 8 had been urged for several years, and the 1994 version is considered to represent a major advance in commercial law, particularly in addressing the realities of indirect holding, and also in addressing global trading. One of the most important objectives of the 1994 version of Article 8, generally referred to in this book simply as Article 8, was to promote finality of transactions and thereby allow securities transfers to be processed without disruption or delay. This was achieved by limiting the exposure of transferees to adverse claims, virtually eliminating doubts about finality by providing that investors holding through intermediaries do not have an interest in any particular security, or even any particular fungible bulk of securities, which can be traced and recaptured from all but a limited class of purchasers. A second principal objective was to build enough flexibility into the system to prevent it from quickly becoming obsolete due to future innovations in securities holding patterns, as had happened to the 1978 version, or investment assets. This was achieved by providing that the rules of the indirect holding system apply to any financial asset, a broad term discussed in detail in Chapter 4.a, by introducing some party autonomy into the definition of security, discussed immediately infra, and by structuring the rights of investors holding through intermediaries so as to be dependent primarily on those intermediaries, rather than on third parties. A third significant goal was to provide clear and logical choice of law rules for both sales and secured transactions so as not to inhibit globalization of securities transactions. Choice of law is discussed in Chapter 6. See scope of Article 8. As noted above, Article 8 provides the commercial law rules for the acquisition, holding, and transfer of interests in securities and certain other investment property. Central to the scope of Article 8 are its definitions of security, financial asset, and security entitlement. The definition of security contained in 8-102, with help from 8-103, has little to do with the definition of security that has developed for purposes of the federal securities laws. Article 8's definition is intended to cover assets that one would normally expect to be bought and sold as securities in today's marketplace, and has essentially four components. First, the asset must be either an obligation of an issuer, such as a bond, note, or other debt, or a share, participation, or other interest in the issuer or in the issuer's property, such as a share of stock. Chapter 2 discusses Article 8's rules regarding the issuer's obligations to the owner of securities issued by it. Second, the asset must take one of three forms. It may be in bearer form, i.e., evidenced by a physical certificate entitling the holder, the bearer, to the rights that the asset is intended to represent. Alternatively, it may be in registered form, i.e., evidenced by a physical certificate entitling the person registered as the owner on the books of the issuer to the rights the asset is intended to represent. It may not be order paper, i.e., an obligation payable to the order of a payee, such as a check or commercial paper. Finally, a security may be uncertificated, i.e., evidenced only by an entry in the books of the issuer, as envisioned by the 1978 version of Article 8. All uncertificated securities are, of course, registered. Third, the asset must be one of a class or series or, by its terms, be divisible into a class or series of shares, participations, interests, or obligations. This requirement assists in distinguishing securities from ordinary negotiable instruments. This provision does not require that there be more than one item in the class or series. It is also satisfied by, for example, a single certificate representing all of the outstanding shares of stock of a closely held issuer, so long as it is by its terms divisible. Thus a jumbo, i.e., very large, certificate would satisfy this component, but a global, i.e., one that evidences the entire class or series and that is not divisible, certificate would not. Fourth and finally, the asset must function like a security. It must ordinarily be, or be of a type that is, dealt in or traded on a securities exchange or securities market. Alternatively, this fourth component is satisfied if the asset constitutes a medium for investment and by its terms expressly provides that it is a security governed by Article 8. Thus, the issuer of a medium for investment, such as a partnership or a limited liability company, can opt into the full range of Article 8's coverage of securities. In addition to securities, Article 8 covers a broader array of financial assets, but to a more limited extent. As more fully discussed in Chapter 4.a, financial asset is defined to include securities, other obligations, or interests which are, or are of a type dealt in or traded on financial markets or considered a medium for investment, and any property held in a securities account which the securities intermediary has agreed to treat as a financial asset. Article 8 applies to financial assets that are not securities only insofar as they are held in a securities account, i.e., in the indirect holding system discussed below. Expressed another way, the only interest in non-securities financial assets to which Article 8 applies is a security entitlement to them, a bundle of rights which is part property interest in assets held through, and part in personam claim against, a securities intermediary. This concept, which is crucial to the statute's treatment of securities, too, is discussed in detail in Chapter 4. By contrast, Article 8 covers securities in a relatively expansive manner, providing not only for the indirect holding system but also for the rights and obligations of issuers, purchasers, transferors, and others in the direct holding system. The importance of this distinction between securities and other financial assets is highlighted by 8 to 103, which is devoted to classifying certain otherwise potentially difficult cases one way or the other. This section makes explicit that shares of stock in any corporation, even a closely held one, are securities, as are similar equity interests issued by business trusts, joint stock companies, and similar entities, whether or not the particular issue is dealt in or traded on a securities exchange or market. By contrast, an interest in a partnership or limited liability company is not a security, unless it is so dealt in or traded, or unless the opt-in provision discussed above applies. If a partnership or LLC interest is not a security, it is nonetheless a financial asset if it is held in a securities account. Article 8's division into rules for the direct and indirect holding systems under Article 8, an essential distinction is whether one has a direct relationship with the issuer, as when one is a record owner or the holder of a bearer security, or an indirect relationship with the issuer, as when one holds the investment through one or more intermediaries. Because the differences between direct and indirect holding are so significant, Article 8 treats them as separate systems requiring different legal concepts. The system in which investors have a direct relationship with the issuer is known as the direct holding system. The rules for this system apply only to securities, not to other financial assets. In the direct holding system, securities intermediaries and securities accounts are not involved. Instead, each investor is registered as the owner on the books of the issuer, which are often maintained by a transfer agent. The system in which investors hold interests in securities or other financial assets through intermediaries in securities accounts is known as the indirect holding system. The indirect holding system is not entirely independent of the direct holding system. In the case of securities, the entity at the top of the chain of indirect ownership has a direct holding system relationship with the issuer. This linkage between the two systems, as well as some typical relationships within the indirect holding system. For example, if the financial assets in question are shares of stock in Computer Corporation, investor number 1 has a security entitlement to those shares credited to its securities account maintained with broker number 1. Broker number 1, in turn, has the same relationship with DDC. And, finally, DDC, or, more precisely, its nominee, Seed & Co., is the registered owner of the shares on the books of Computer Corporation. The same analysis applies whether the Computer Corporation shares registered to DDC are certificate or uncertificated. Article 8's classification of ownership depends more fundamentally on how securities are held than on how they are evidenced. The direct holding system is the subject of Chapters 2 and 3. The indirect holding system is the subject of Chapter 4. Regulations concerning federal book entry securities. Recent regulations issued by the United States Treasury parallel, and, in certain cases, incorporate, the 1994 version of Article 8. These regulations govern many aspects of transactions involving securities issued by the United States Treasury and maintained in the Treasury/Reserve Automated Debt Entry System, TRADES, which utilizes the commercial book entry system operated by the Federal Reserve Banks. Nearly identical regulations have also been issued by the various other government-sponsored entities that maintain securities in the Federal Reserve Bank's book entry system, such as the Federal National Mortgage Association, known as Fannie Mae, and the Federal Home Loan Mortgage Corporation, known as Freddie Mac. Persons holding Treasury securities in trades do so through a tiered system of securities accounts. The Treasury, acting through its fiscal agents, the Federal Reserve Banks, recognizes the identity only of participants, i.e., entities maintaining direct securities account relationships in their name with the Federal Reserve Bank. Persons that are not participants can hold beneficial interests in Treasury securities through one or more securities intermediaries and generally may exercise their rights only through those entities. The trades regulations, which are codified at 31 CFR Part 357, follow a bifurcated structure, applying federal substantive law to certain aspects of transactions at the Federal Reserve Bank level and deferring to other applicable law in other instances. In a significant change from prior regulations, the trades regulations have clear choice of law rules paralleling the new ones of Article 8. They also provide that, for certain purposes, if the jurisdiction to which such rules refer is a state, defined to include the District of Columbia and U.S. territories and possessions, that has not adopted the 1994 version of Article 8, the trades regulations will apply the law of such state as though the state had adopted it. This incorporation of Article 8 is designed to ensure uniformity in the law applied to transactions in Treasury securities where federal substantive law does not otherwise govern. Persons may also hold interests in Treasury securities through Treasury Direct. In this system, a beneficial owner maintains a direct account relationship with the Treasury. No secondary market trading or pledging of book entry securities held through Treasury Direct may be effected under current regulations, however. These regulations, which are also codified at 31 CFR Part 357, do not incorporate Article 8 in any way. 6. Licenses and privileges. A license as defined in Black's Law Dictionary is, certificate or the document itself which gives permission, authority or liberty given to do or forbear any act, permission to do a particular thing or to exercise a certain privilege or to carry on a particular business or to pursue a certain occupation. Privilege from state or sovereign. The words admit and license as used in statute providing that power to admit and license persons to practice as attorneys is vested exclusively in the Supreme Court are inseparable and refer to the same thing. Now in Bouvier's dictionary it reads, license, contracts. A right given by some competent authority to do an act, which without such authority would be illegal. The instrument or writing which secures this right, is also called a license. Videal. Parag. 353, 15 Ven. About 92, ANG Watt. Co 61, 85. 2. A license is express or implied. An express license is one which in direct terms authorizes the performance of a certain act. Constitutional law and contract law as defined in Black's Law is, a permission, by a competent authority to do some act which without such authorization would be illegal, or would be a trespass or a tort. Also the written evidence of permission. A license is not a contract between the state and the licensee, but is a mere personal permit. Neither is it a property or a property right. Marriage license in Black's Law Dictionary reads a license or permission granted by public authority to persons who intend to intermarry. By statute in some jurisdictions, it is made an essential prerequisite to the lawful solemnization of the marriage. Privilege in Black's Law reads, a particular and peculiar benefit or advantage enjoyed by a person, company, or class, beyond the common advantages of other citizens. Civil law in Black's it reads, a right which the nature of a debt gives to a creditor, and which entitles him to be preferred before other creditors. Privileges and immunities in Black's Law reads, within the meaning of the 14th Amendment of the United States Constitution, such privileges as are fundamental, which belong to the citizens of all free governments and which have at all times been enjoyed by citizens of the United States. Now the definition of privilege from Bouvier's. Privilege, civil law. A right which the nature of a debt gives to a creditor, and which entitles him to be preferred before other creditors. Now please do not forget the definition of contract and the power of its association between parties. Again from Bouvier's we find a contract to read. Contract. This term, in its more extensive sense, includes every description of agreement, or obligation, whereby one party becomes bound to another to pay a sum of money, or to do or omit to do a certain act, or, a contract is an act which contains a perfect obligation. In its more confined sense, it is an agreement between two or more persons, concerning something to be done, whereby both parties are bound to each other, or one is bound to the other. Now that you have some idea of what licenses, privileges and contracts are, let's look at Bouvier's to see what voluntary reads. Voluntary. Willingly, done with one's consent, negligently. To render an act criminal or tortious it must be voluntary. And if he commit an injury to the person or property of another, he is not liable for damages, unless the act has been voluntary or through negligence, as when a collision takes place between two ships without any fault in either. This next definition should really be a helpful one for most folks while understanding the nature and cause of law or contracts. Please try to understand how important this word is with law and contracts. Mistake, contracts. An error committed in relation to some matter of fact affecting the rights of one of the parties to a contract. Two mistakes in making a contract are distinguished ordinarily into, first, mistakes as to the motive, secondly, mistakes as to the person, with whom the contract is made, thirdly, as to the subject matter of the contract, and, lastly, mistakes of fact and of law. See Story, EQ Jur. Sector 110, Bouv. INST Index, HT, Ignorance, Motive. 3. In general, courts of equity will correct and rectify all mistakes in deeds and contracts founded on good consideration. 1 VS. 317, 2 ATK. 203, MIF. PL 116, 4 Ven. About 277, 13 Ven. About 41, 18 E Commander Law Representatives 14, 8 Commander Digest, 75, Mad. CH Brook. Index, HT, 1 Story on EQCH5, P 121, Jeremy's EQ Jurist. B3, Part 2, P 358. See article Surprise. 4. As to mistakes in the names of legatees, see 1 ROP. Leg. 131, Domat. L4, T2, S1, and 22. As to mistakes made in practice, and as to the propriety or impropriety of taking advantage of them, see Chit. Prince Index. HT. As to mistakes of law in relation to contracts, see 23 AM Jur. 146 to 166. Now for the liability part of these licenses and privileges. Let's go to Bouvier's dictionary and we see that liability reads. Liability. Responsibility, the state of one who is bound in law and justice to do something which may be enforced by action. This liability may arise from contracts either express or implied, or in consequence of torts committed. Licenses are grants and privileges, and because they are contracts they are consensual in nature. I.e., they are voluntary. Let's start with the birth records. In order for you to understand the birth records and vital statistics agencies, you must first learn what their own regulations and definitions mean. Please visit your state regulator for information pertaining to a state birth document. This definition comes from Mississippi and it reads: live birth means the complete expulsion or extraction from its mother of a product of human conception. What is a human? Merriam-Webster says that the adjective human is of relating to, being, or characteristic of humans, having human forms or attributes. However, let me take you to Black's Law Dictionary and read the definition of man as used in law: a vassal, a tenant or feudatory. The Anglo-Saxon relation of lord and man was originally purely personal and founded on mutual contract. Now for the Black's Law definition of husband and wife: the legal existence of a wife is incorporated with that of her husband. Now with this in mind, remember the words, product, relating to or having a characteristic of a tenant with his wife who is incorporated with him. Wow, this really is sounding like we have been used for commercial gains or resources as well as being tricked into contracting everywhere we turn. Let's continue with more on state or governmental contracts, I mean identifications. http://www.ssa.gov/pub/10023.html number sign must. Must my child have a social security number? No. But it is a very good idea to apply for a number right after your baby is born. Getting a social security number for your newborn is voluntary. You should apply for your baby's number before the child is 1 year old. If you do not, it may take up to 12 weeks longer, because we will contact the state office that issued the birth record to verify the record. We do this to prevent people from using fraudulent birth records to obtain social security numbers to establish false identities. http://www.sospublius.org/help/how-to-register.asp. To register to vote in Michigan, you must be a U.S. citizen, at least 18 years of age by election day, a resident of Michigan and the city or township where you are applying to register to vote, where, in Michigan, your voter registration for all federal, state, and local elections is maintained by your local city or township clerk. You should register to vote at your clerk's office. Be sure to read the information below and then use the link at the bottom of the page to locate your clerk. Voters may also register to vote by mail, at your county clerk's office or by visiting any Secretary of State branch office. In addition, specified agencies providing services through the Family Independence Agency, the Department of Community Health, and the Department of Career Development offer voter registration services to their clients. Military recruitment centers also provide voter registration services. Let's look at a couple more court cases to see what they said again. The court below held and the board contends that the appellant did not become a citizen of Maryland, under the provisions of the Maryland Constitution, until he became a citizen of the United States, and is therefore ineligible to be Sheriff of Baltimore City because he was not a United States citizen at least 5 years preceding the election. We disagree. Both before and after the 14th Amendment to the Federal Constitution, it has not been necessary for a person to be a citizen of the United States in order to be a citizen of his state. United States v. Cruikshank, 92 U.S. 542, 549, 1875, Slaughterhouse Cases, 83 U.S., 16 Wall. 36, 73-74, 1873, and C. Short v. State, 80 MD 392, 401-02, 31 Atlantic 322, 1895. See also Speer, State Citizenship, 16 Albany LJ 24, 1877. Citizenship of the United States is defined by the 14th Amendment and federal statutes, but the requirements for citizenship of a state generally depend not upon definition but the constitutional or statutory context in which the term is used. Ryswick v. Davis, 19 MD 82, 93, 1862, Halaby v. Board of Directors of University of Cincinnati, 162 Ohio Street 290, 293, 123 NE2D3, 1954, and authorities therein cited. Laurel and Pinero Miller v. Madeline K. Albright April 22, 1998 Justice Stevens announced the judgment of the court and delivered an opinion, in which the Chief Justice joined. There are two sources of citizenship, and two only, birth and naturalization. United States v. Wong Kim Ark, 169 U.S. 649, 702, 1898. Within the former category, the 14th Amendment of the Constitution guarantees that every person born in the United States, and subject to the jurisdiction thereof, becomes at once a citizen of the United States, and needs no naturalization. 169 U.S., at 702. Persons not born in the United States acquire citizenship by birth only as provided by acts of Congress. ID, at 703. Court case referring to marriage license No. 5-97-0108 in the Appellate Court of Illinois 5th District Carolyn A. West and John W. West. Petitioners and cross-appellees v. Ginger West, Respondent and cross-appellant. Appeal from the Circuit Court of Jefferson County. No. 93 F92 Honorable Terry H. Gamber, Judge, presiding. Justice Maag delivered the opinion of the court. This action was brought in April of 1993 by Carolyn and John West, grandparents, to obtain visitation rights with their grandson, Jacob Dean West. Jacob was born January 27, 1992. He is the biological son of Ginger West and Gregory West, Carolyn and John's deceased son. In June of 1993, when Jacob was approximately 17 months old, the grandparents were granted accelerating visitation privileges. The issue presented for review on appeal is whether Section 607, b, of the Illinois Marriage and Dissolution of Marriage Act, Act, 750 ILCS 5/607, b. West 1996, insofar as it pertains to grandparental visitation privileges, is unconstitutional as violative of the fundamental liberty rights of parents to the care and custody of their children, which are guaranteed to them by the 14th Amendment to the United States Constitution and Article 1, Section 2, of the Constitution of the State of Illinois. We begin our analysis of this issue with the presumption that the challenged provision of the Visitation Statute is constitutional. See Tully v. Edgar, 171 IL 2D 297, 304, 664 N.E.2D 43, 47, 1996. The court has a duty to construe enactments so as to sustain their constitutionality and validity, if reasonably possible. People v. Warren, 173 IL 2D 348, 355. 671 N.E.2D 700, 705, 1996. Keeping these principles in mind, we now proceed with our analysis. Ginger begins her argument with a discussion of the long-recognized constitutionally protected interest of parents to raise their children without undue state influence. See Meyer v. Nebraska, 262 U.S. 390, 399, 67 L. ed. 1042, 43 SCT 625, 626, 1923, Pierce v. Society of the Sisters of the Holy Names of Jesus and Mary, 268 U.S. 510, 534-35, 69 L. ed. 1070, 45 SCT 571-73, 1925, Prince v. Massachusetts, 321 U.S. 158, 166, 88 L. ed. 645, 64 SCT 438, 442, 1944, Wisconsin v. Yoder, 406 U.S. 205, 235, 32 L. ed. 2D15, 92 SCT 1526, 1543, 1972, Santosky v. Kramer, 455 U.S. 745, 753, 71 L. ed. 2D 599, 102 SCT 1388, 1394, 1982. However, this constitutionally protected parental interest is not wholly without limit or beyond regulation. Prince v. Commonwealth of Massachusetts, 321 U.S. 158, 166, 88 L. ed. 645, 64 SCT 438, 442, 1944. The state has a wide range of power for limiting parental freedom and authority in things affecting the child's welfare. Prince, 321 U.S. at 167, 88 L. ed. 645, 64. SCT at 442. In fact, the entire familial relationship involves the state. When two people decide to get married, they are required to first procure a license from the state. If they have children of this marriage, they are required by the state to submit their children to certain things, such as school attendance and vaccinations. Furthermore, if at some time in the future the couple decides the marriage is not working, they must petition the state for a divorce. Marriage is a three-party contract between the man, the woman, and the state. Linneman v. Linneman, 1 IL App 2D 48, 50, 116 N.E.2D 182, 183, 1953, citing Venkatan v. Venkatan, 323 IL 323, 326, 154 NE 146, 1926. The state represents the public interest in the institution of marriage. Linneman, 1 IL App 2D at 50, 116 N.E.2D at 183. This public interest is what allows the state to intervene in certain situations to protect the interests of members of the family. The state is like a silent partner in the family who is not active in the everyday running of the family but becomes active and exercises its power and authority only when necessary to protect some important interest of family life. Taking all of this into consideration, the question no longer is whether the state has an interest or place in disputes such as the one at bar, but it becomes a question of timing and necessity. Has the state intervened too early or perhaps intervened where no intervention was warranted? This Question then directs our discussion to an analysis of the provision of the Act that allows the challenged state intervention, 750 ILCS 5/607, b. West 1996. A statute will be construed as changing common law only to the extent that the terms thereof warrant, or as necessarily implied from what is expressed. Hawkins v. Hawkins, 102 IL App 3D 1037, 1039, 430 N.E.2D 652, 654, 1981, citing Sternberg Dredging Co. v. Sternberg's estate, 10 IL 2D 328, 140 N.E.2D 125, 1957, Acme Fireworks Corp. v. Bibb, 6 IL 2D 112, 126 N.E.2D 688, 1955, People v. Monison, 75 IL App 3D 1, 393 N.E.2D 1239, 1979. Repeal of the common law by implication is not favored. Hawkins, 102 IL App 3D at 1039, 430 N.E.2D at 654. Rather, we believe that the legislature was codifying the common law and simultaneously expanding grandparental visitation. This amendment comes as a promise of relief to some who feel the state has overstepped its purview by meddling with what they call a sacred right for parents, to decide who their children should have contact with. 25 FAM LQ at 75, quoting Kendall, Grandparents' Rights Challenged, CHI-TRIB, June 4, 1990, 2, at 1. Only in the case of a disrupted family does the state seek to intervene, and only then to protect the interests of those who cannot protect their own interests. This is the same way the issue of grandparental visitation was handled in the courts before the enactment of the visitation statute. We realize that the challenged statute and the common law it codifies allow the state to act upon a constitutionally recognized fundamental right of parents. Where a statute infringes upon a fundamental constitutional right, that statute may be upheld only if a compelling state interest exists to achieve a stated goal. Tully v. Edgar, 171 IL 2D 297, 304-05, 664 N.E.2D 43, 47, 1996. The least restrictive means necessary must be used to attain the goal. Tully, 171 IL 2D at 305, 664 N.E.2D at 47. Now read the section in the Bar News for the state of Michigan and use your imagination regarding deceptive trade practices vs agency policies or rules. http://www.michigan.gov/documents/BAR News 00_25346_7.pdf. Volume 20, Issue 1. Candace S. Miller, Secretary of State. In this issue, the Bureau of Automotive Regulations legal advisors recently concluded that language which limits the consumer's right to remedies prescribed by law is considered an unfair and deceptive practice under Michigan law. Using invoices which contain language such as disputes arising out of alleged breach of the repair order shall be settled by binding arbitration pursuant to the rules of the American Arbitration Association or similar terminology, as well as each party shall bear its own costs, including legal fees, is an unfair and deceptive practice. Such arbitration language violates the Motor Vehicle Service and Repair Act and administrative rules on several grounds. Section 36, MCL 257.1336, allows a customer to recover damages plus attorney fees and costs. Rule 31, 1a, prohibits contracts which use a waiver to circumvent or evade the Motor Vehicle Service and Repair Act. Rule 31, 2c, prohibits repair facilities from entering into a contract which attempts to abrogate, disclaim, or disallow legal rights, obligations, or remedies of a customer. And Rule 31, 2f, prohibits any attempt to avoid or evade invoice language may be deceptive practice the law through a contract or any provision thereof. If your invoices contain such language, on the front or back, you should strike out the language or replace the invoices to avoid the issuance of violation notices. Most invoice suppliers have been notified that this type of language is illegal and have made modifications. I would like to finish this chapter off with an exercise for all to take part in. Please take a peek at http://www.access.gpo.gov/nara/cfr/cfr-table-search.html number sign page 1. This is NARA's website for the Code of Federal Regulations. Please attempt to find Title 2 of the Code of Federal Regulations. If you have noticed it is not there, As a matter of fact, there isn't even a title for the section, so you cannot even find out what the section refers to. All it states is, reserved. Well, upon requesting specifics from the NARA FOIA department, a beta test link was sent, and this is what the link and content are. http://ecfr.gpoaccess.gov/cgi/t/text/text-id:/ecfr&c=c=t/title02/2 tab_02/2tab_02.tpl. Title 2 Grants and Agreements Volume Chapter Browse Parts Regulatory Entity 1 Subtitle A Office of Management and Budget Guidance for Grants and Agreements 1 I-100 to 199 Reserved 200 to 214 Reserved 215 to 216 to 219 Reserved Office of Management and Budget Circulars and Guidance Subtitle B Federal Agency Regulations for Grants and Agreements 200 to 214 Reserved 215 to 216 to 219 Reserved Office of Management and Budget Circulars and Guidance Subtitle B Federal Agency Regulations for Grants and Agreements. Notice most is still reserved. The exercise is to find out as much as possible and try to gain a copy of the entire Title of 2 Code of Federal Regulations. It seems funny that the very section that deals with grants and agreements are mostly reserved from the public when it has to deal with the rules, regulations, and definitions of the very grants and agreements with the United States government. Let's see some that is published. Title 2, Grants and Agreements Part 1 about Title 2 of the Code of Federal Regulations and Subtitle A Subpart A Introduction to Title 2 of the CFR 1.105 Organization and Subtitle Content. A. This title is organized into 2 subtitles. B. The OMB guidance described in 1.100, A, is published in Subtitle A. Publication of the OMB guidance in the CFR does not change its nature, it is guidance and not regulation. C. Each federal agency that publishes regulations implementing the OMB guidance has a chapter in Subtitle B in which it issues those regulations. The federal agency regulations in Subtitle B differ in nature from the OMB guidance in Subtitle A because the OMB guidance is not regulatory. Federal agency regulations in Subtitle B may give regulatory effect to the OMB guidance, to the extent that the agency regulations require compliance with all or portions of the guidance. Wonder why it is the regulations governing the agencies within is not published? 1.210 Applicability to federal agencies and others. A. This subtitle contains guidance that directly applies only to federal agencies. B. The guidance in the subtitle may affect others through each federal agency's implementation of the guidance, portions of which may apply to 1. The agency's awarding or administering officials. 2. Non-federal entities that receive or apply for the agency's grants or agreements or receive subawards under those grants or agreements, or 3. Any other entities involved in agency transactions subject to the guidance in this chapter. 1.305 Federal Agency Responsibilities. The head of each federal agency that awards and administers grants and agreements subject to the guidance in the subtitle is responsible for A. Implementing the guidance in the subtitle. B. Ensuring that the agency's components and subcomponents comply with the agency's implementation of the guidance. C. Performing other functions specified in the subtitle. 215.2 Definitions. E. Award means financial assistance that provides support or stimulation to accomplish a public purpose. Awards include grants and other agreements in the form of money or property in lieu of money, by the federal government to an eligible recipient. The term does not include technical assistance, which provides services instead of money, other assistance in the form of loans, loan guarantees, interest subsidies, or insurance, direct payments of any kind to individuals, and contracts which are required to be entered into and administered under procurement laws and regulations. 215.42 Codes of Conduct. The recipient shall maintain written standards of conduct governing the performance of its employees engaged in the award and administration of contracts. No employee, officer, or agent shall participate in the selection, award, or administration of a contract supported by federal funds if a real or apparent conflict of interest would be involved. Such a conflict would arise when the employee, officer, or agent, any member of his or her immediate family, his or her partner, or an organization which employs or is about to employ any of the parties indicated herein, has a financial or other interest in the firm selected for an award. The officers, employees, and agents of the recipient shall neither solicit nor accept gratuities, favors, or anything of monetary value from contractors, or parties to subagreements. However, recipients may set standards for situations in which the financial interest is not substantial or the gift is an unsolicited item of nominal value. The standards of conduct shall provide for disciplinary actions to be applied for violations of such standards by officers, employees, or agents of the recipient. 215.61 Termination. A. Awards may be terminated in whole or in part only if paragraphs A, 1, 2, or 3 of this section apply. 1. By the federal awarding agency, if a recipient materially fails to comply with the terms and conditions of an award. 2. By the federal awarding agency with the consent of the recipient, in which case the two parties shall agree upon the termination conditions, including the effective date and, in the case of partial termination, the portion to be terminated. 3. By the recipient upon sending to the federal awarding agency written notification setting forth the reasons for such termination, the effective date, and, in the case of partial termination, the portion to be terminated. However, if the federal awarding agency determines in the case of partial termination that the reduced or modified portion of the grant will not accomplish the purposes for which the grant was made, it may terminate the grant in its entirety under either paragraphs A, 1, or 2 of this section. B. If costs are allowed under an award, the responsibilities of the recipient referred to in 215.71 A, including those for property management as applicable, shall be considered in the termination of the award, and provision shall be made for continuing responsibilities of the recipient after termination, as appropriate. So now you can see that the very grants and agreements section of the CFR is paramount, yet mostly hidden, to research. If you do not believe this, please take a look at how the USC and the CFR is set up to begin with. The United States Code is the codification by subject matter of the general and permanent laws of the United States based on what is printed in the statutes at large. It is divided by broad subjects into 50 titles and published by the Office of the Law Revision Council of the U.S. House of Representatives. Since 1926, the United States Code has been published every 6 years. In between editions, annual cumulative supplements are published in order to present the most current information. Documents are available only as ASCII text files. GPO Access contains the 2000 and 1994 editions of the U.S. Code, plus annual supplements. At this time, the statutes at large is not available on GPO Access. When a section is affected by a law passed after a supplement's revision date, the header for that section includes a note that identifies the public law affecting it. In order to find the updated information, you must search the public laws databases for the referenced public law number. The U.S. Code on GPO Access is the official version of the code, however, 2 unofficial editions are available. These are the U.S.C.A, U.S. Code Annotated, and the USCS, U.S. Code Service. The USCA and USCS contain everything that is printed in the official U.S. Code but also include annotations to case law relevant to the particular statute. While these unofficial versions may be more current, they are not official and not available from the U.S. Government Printing Office. Note, of the 50 titles, only 23 have been enacted into positive, statutory, law. These titles are 1, 3, 4, 5, 9, 10, 11, 13, 14, 17, 18, 23, 28, 31, 32, 35, 36, 37, 38, 39, 44, 46, and 49. When a title of the code was enacted into positive law, the text of the title became legal evidence of the law. Titles that have not been enacted into positive law are only prima facie evidence of the law. In that case, the statutes at large still govern. The U.S. Code does not include regulations issued by executive branch agencies, decisions of the federal courts, treaties, or laws enacted by state or local governments. Regulations issued by executive branch agencies are available in the Code of Federal Regulations. Proposed and recently adopted regulations may be found in the Federal Register. To view the United States Code, http://www.gpoaccess.gov/uscode/browse.html. Our note, look at the change in the current title name of Title 27. A service of the U.S. Government Printing Office. Last updated, September 27, 2003. Page name, http://www.gpoaccess.gov/uscode/about.html. To locate in U.S. Code, look for identical section number in Title 26, Internal Revenue Code. PL 99-514, 2a, provides that the Internal Revenue Title enacted August 14, 1954, may be cited as the Internal Revenue Code of 1986, and 2, b, provides, except when inappropriate, any reference to the Internal Revenue Code of 1954 shall include a reference to the Internal Revenue Code of 1986, and any reference to the Internal Revenue Code of 1986 shall include a reference to the provisions of the Internal Revenue Code of 1954. Codification Legislation Office of the Law Revision Council. What is positive law codification? Positive law codification is the process of preparing and enacting, one title at a time, a revision and restatement of the general and permanent laws of the United States. Because many of the general and permanent laws that are required to be incorporated into the United States Code are inconsistent, redundant, and obsolete, the Office of the Law Revision Council of the House of Representatives has been engaged in a continuing comprehensive project authorized by law to revise and codify, for enactment into positive law, each title of the Code. When this project is completed, all the titles of the Code will be legal evidence of the general and permanent laws, and recourse to the numerous volumes of the United States statutes at large for this purpose will no longer be necessary. Positive law codification bills prepared by the office do not change the meaning or legal effect of a statute being revised and restated. Rather, the purpose is to remove ambiguities, contradictions, and other imperfections from United States Code classification tables. Office of the Law Revision Council. http://uscode.house.gov/uscct.htm. These tables show where recently enacted laws will appear in the United States Code and which sections of the Code have been amended by those laws. The tables sorted in public law order may be used to identify the sections of the Code affected by a particular law. The tables sorted in code order may be used to determine whether a particular section of the Code has recently been amended. The tables only include those provisions of law that have been classified to the Code. The text of recently enacted laws may be found through the Library of Congress Thomas website. 7. UCC and banking. Most folks will agree that banking transactions such as a loan would be covered under Article 3 entitled Negotiable Instruments. However, by doing a little more investigation you may find differently. When reading any section of law, it is most important to read the applicability, subject matter, or in easier terms the topics the specific sections covers to begin with. When you look in Article 3 itself, you will find that at Section 3 to 102 it reads 3 to 102. Subject matter. A. This article applies to negotiable instruments. It does not apply to money, to payment orders governed by Article 4A, or to securities governed by Article 8. B. If there is conflict between this article and Article 4 or 9, Articles 4 and 9 govern. C. Regulations of the Board of Governors of the Federal Reserve System and operating circulars of the Federal Reserve Bank supersede any inconsistent provision of this article to the extent of the inconsistency. Now this speaks about Articles 4, 8, and 9. Now in Chapter V that Article 9 is inapplicable with these items as well. See 9 to 109, 4 to 11, so this leaves Articles 4 and 8. Now again let's go to Article 4 and see what it states about what Article 4 applies to. 4 to 102. Applicability. A. To the extent that items within this article, 4 to 104, are also within Articles 3 and 8, they are subject to those articles. If there is conflict, this article governs Article 3, but Article 8 governs this article. B. The liability of a bank for action or non-action with respect to an item handled by it for purposes of presentment, payment, or collection is governed by the law of the place where the bank is located. In the case of action or non-action by or at a branch or separate office of a bank, its liability is governed by the law of the place where the branch or separate office is located. Now we can see that we should go to Article 8 for a clear understanding of what it covers. If you go into Article 8 you will see that 8 to 102 is definitions, and nowhere else can you find a title section caption of neither subject matter nor applicability. This tells me that we must now be at the root of the topic, because there are no other references nor statements stating if, or go to, or to the extent in, or except as provided in. So now we see that Article 8 is the key. Let's go back to the document itself again. The loan or note that you signed with the bank. In doing this, this will take us back to Article 3 to find out what exactly Article 3 states it is and what exactly happened. First let's find out what the section tells us is a negotiable instrument to begin with. 3 to 104. Negotiable instrument. A. Except as provided in subsections C and D. Negotiable instrument means an unconditional promise or order to pay a fixed amount of money, with or without interest or other charges described in the promise or order, if it 1. is payable to bearer or to order at the time it is issued or first comes into possession of a holder. 2. Is payable on demand or at a definite time, and 3. Does not state any other undertaking or instruction by the person promising or ordering payment to do any act in addition to the payment of money, but the promise or order may contain I. An undertaking or power to give, maintain, or protect collateral to secure payment. 2. An authorization or power to the holder to confess judgment or realize on or dispose of collateral, or 3. A waiver of the benefit of any law intended for the advantage or protection of an obliger. B. Instrument means a negotiable instrument. C. An order that meets all of the requirements of subsection A, except paragraph 1, and otherwise falls within the definition of check in subsection F, is a negotiable instrument and a check. D. A promise or order other than a check is not an instrument if, at the time it is issued or first comes into possession of a holder, it contains a conspicuous statement, however expressed, to the effect that the promise or order is not negotiable or is not an instrument governed by this article. E. An instrument is a note if it is a promise and is a draft if it is an order. If an instrument falls within the definition of both note and draft, a person entitled to enforce the instrument may treat it as either F. Check means I. A draft, other than a documentary draft, payable on demand and drawn on a bank, or 2. A cashier's check or teller's check. An instrument may be a check even though it is described on its face by another term, such as money order. See, this is actually a draft. It does order payment. You are ordering the bank to pay based upon your promise. Therefore it falls under the category of draft, i.e. not a negotiable instrument. Now let's make sure of this. In order to do so, we need to look at the issue and issuer section to find out who really issued this loan or note. 3 to 105. Issue of instrument. A. Issue means the first delivery of an instrument by the maker or drawer, whether to a holder or non-holder, for the purpose of giving rights on the instrument to any person. 3 to 103. Definitions. A. In this article. 2. Drawee means a person ordered in a draft to make payment. 3. Drawer means a person who signs or is identified in a draft as a person ordering payment. 4. Reserved, this wonderful good faith clause again removed on Cornell Online. 5. Maker means a person who signs or is identified in a note as a person undertaking to pay. Well, based on the above, who ordered payment? If you think the bank, ask yourself one question. Absent your signature, what agreement is there? They cannot order payment without you consenting to it. Also, under maker it is much clearer by asking yourself who is the one paying. So this proves that you are the issuer and not the bank. This now makes a whole bunch more sense, especially when the first couple chapters you learned that the debtor moves rights and property, not the secured party. Now you realize the bank tricked you into believing they issued, when in fact you did. If you still believe the bank loaned you their money and the bank issued the loan, please cross-reference with 12 U.S.C. Chapter 2 Subchapter 4 Section 83. For the root of the section, please see Title 62 of the Revised Statutes and read Chapter 4 sometime. Back to the UCC side of this. Now we see this is all about assets. It's not identified whose asset yet, but it is definitely an asset. Now Article 3 took us to Article 4 and Article 4 takes us to 8 by their own admissions. If there is a conflict, now we need to go to Article 8 to find out who is entitled and who is not. First, you need to see some definitions to see what Article 8 states these words mean in this article. 8 to 102. Definitions. 1. Adverse claim means a claim that a claimant has a property interest in a financial asset and that it is a violation of the rights of the claimant for another person to hold, transfer, or deal with the financial asset. 2. Bearer form, as applied to a certificate security, means a form in which the security is payable to the bearer of the security certificate according to its terms but not by reason of an endorsement. 3. Broker means a person defined as a broker or dealer under the federal securities laws, but without excluding a bank acting in that capacity. 7. Entitlement holder means a person identified in the records of a securities intermediary as the person having a security entitlement against the securities intermediary. If a person acquires a security entitlement by virtue of Section 8-501, B, 2, or 3, that person is the entitlement holder. 9. Financial asset, except as otherwise provided in Section 8 to 103, means I. A security. 2. An obligation of a person or a share, participation, or other interest in a person or in property or an enterprise of a person, which is, or is of a type, dealt in or traded on financial markets, or which is recognized in any area in which it is issued or dealt in as a medium for investment, or 3. Any property that is held by a securities intermediary for another person in a securities account if the securities intermediary has expressly agreed with the other person that the property is to be treated as a financial asset under this article. As context requires, the term means either the interest itself or the means by which a person's claim to it is evidenced, including a certificate or uncertificated security, a security certificate, or a security entitlement. 10. Reserved here is that good faith clause again, yet not on Cornell's website. 15. Security, except as otherwise provided in section 8 to 103, means an obligation of an issuer or a share, participation, or other interest in an issuer or in property or an enterprise of an issuer. 17. Security entitlement means the rights and property interest of an entitlement holder with respect to a financial asset specified in Part 5. 8 to 103. Rules for determining whether certain obligations and interests are securities or financial assets. D. A writing that is a security certificate is governed by this article and not by Article 3, even though it also meets the requirements of that article. However, a negotiable instrument governed by Article 3 is a financial asset if it is held in a securities account. 8 to 104. Acquisition of security or financial asset or interest therein. A. A person acquires a security or an interest therein, under this article, if 1. The person is a purchaser to whom a security is delivered pursuant to Section 8 to 301, or 2. The person acquires a security entitlement to the security pursuant to Section 8 to 501. B. A person acquires a financial asset, other than a security, or an interest therein, under this article, if the person acquires a security entitlement to the financial asset. C. A. 2. D. Unless the context shows that a different meaning is intended, a person who is required by other law, regulation, rule, or agreement to transfer, deliver, present, surrender, exchange, or otherwise put in the possession of another person a security or financial asset satisfies that requirement by causing the other person to acquire an interest in the security or financial asset pursuant to subsection A, or B. Now for the entitlement itself. See in the definition of entitlement holder it refers you to 8105. B. 2 or 3. 8 to 501. Securities account, acquisition of security entitlement from securities intermediary. A. Securities account means an account to which a financial asset is or may be credited in accordance with an agreement under which the person maintaining the account undertakes to treat the person for whom the account is maintained as entitled to exercise the rights that comprise the financial asset. B. Except as otherwise provided in subsections D and E, a person acquires a security entitlement if a securities intermediary 1. Indicates by book entry that a financial asset has been credited to the person's securities account. 2. Receives a financial asset from the person or acquires a financial asset for the person and, in either case, accepts it for credit to the person's securities account, or 3. Becomes obligated under other law, regulation, or rule to credit a financial asset to the person's securities account. C. If a condition of subsection B has been met, a person has a security entitlement even though the securities intermediary does not itself hold the financial asset. D. If a securities intermediary holds a financial asset for another person, and the financial asset is registered in the name of, payable to the order of, or specially indexed to the other person, and has not been indexed to the securities intermediary or in blank, the other person is treated as holding the financial asset directly rather than as having a security entitlement with respect to the financial asset. E. Issuance of a security is not establishment of a security entitlement. Now for those who think the bank is the entitlement holder. 8 to 503. Property interest of entitlement holder in financial asset held by securities intermediary. A. To the extent necessary for a securities intermediary to satisfy all security entitlements with respect to a particular financial asset, all interests in that financial asset held by the securities intermediary are held by the securities intermediary for the entitlement holders, are not property of the